Good morning, ladies and gentlemen. We're going to go ahead and call the meeting to order. This is the Pennington County Planning Commission meeting of May 22nd, 2023. Recommendations of the Planning Commission on certain items from this agenda will be considered by the Board of Commissioners at their regular meeting on June 6, 2023 at 10:30. The 10:30 time is the time they start reviewing planning items. The Planning Commission utilizes speaker request forms, which are available in the commission chambers during the meeting. I've got a number of them for a number of different agenda items already. If you haven't got one in, go ahead and fill it out. First thing is roll call. I see Jim Coleman is the only member that's missing right now. Approval of the minutes of May 8th, 2023 minutes of the meeting. Have you had a chance to review that in your packet? If so,
I've got a correction to note.
sure.
Page 28, third paragraph down, states a date of May 23rd, 2022 for the Planning Commission meeting. It should be the 22nd.
Haven't got to it yet, Kevin. Go ahead.
Oh.
Oh, yes, correct. In the third paragraph?
Yes,
All right. Did you catch that, Jerry?
Which page was that again?
28.
The last page of the minutes.
And with that correction, I move to approve.
Is there a second to that motion? Moved and seconded to approve the minutes of the May 8th, 2023 meeting. Discussion. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. Approval of the agenda, and have you reviewed your agenda that's in your packet for today's meeting? If so, the chair would address a motion to approve the agenda.
So moved.
Second.
Moved and seconded to approve the agenda for the May 22nd, 2023 meeting of the Pennington County Planning Commission. Discussion. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. Jason, go ahead and address the consent agenda, please.
Morning, Commissioners. Jason Fennison is Assistant Planning Director. The following items have been placed on the consent agenda for action to be taken on all items in accordance with staff's recommendation by a single vote. Any item may be removed from the consent agenda by any Planning Commissioner, staff member, or audience member for separate consideration. The findings of this Planning Commission on certain items from this agenda are recommendations to the Pennington County Board of Commissioners, who will make the final decision. Agenda item number 3 is conditional use permit 96-14 for Mark Hirsch to review a manufactured home as a caretaker's residence. And staff recommends approval of the extension of conditional use permit 96-14 with conditions. Agenda item number 4 is conditional use permit review 17-44 for Gregory Yates to review a vacation home rental. Staff recommends approval of the extension of conditional use permit 17-44 with conditions. Agenda item number 5 is conditional use permit review 18-06 for Milbert and Leela Robach to review an existing single-wide mobile home as the owner's residence, an existing single-wide mobile home to remain as storage, and an existing double-wide mobile home to remain as a rental unit on the subject property. And staff recommends approval of the extension of conditional use permit 18-06 with conditions. Agenda item number 6 is conditional use permit review 19-02 for Greg and Angelina Anderson to review a vacation home rental. And staff recommends the approval of extension of conditional use permit 19-02 with conditions. Agenda item number 7 is conditional use permit review 19-19 for Dale and Sarah Gadboy to review a secondary structure prior to a primary residence. And staff recommends to end conditional use permit 19-19 with the applicant's concurrence. Agenda item number 8 is conditional use permit review 19-20 for Cody Russ Butler and Jeannie Marr to review a vacation home rental on the subject property, and staff recommends approval of the extension of conditional use permit 19-20 with conditions. Agenda item number 9 is conditional use permit review 20-25 for Jessica Hessler under Seven Wonders LLC to review a vacation home rental. And staff recommends approval of the extension of conditional use permit 20-25 with conditions. Agenda item number 10 is conditional use permit review 21-04 for Cole and Renee Foster to review a bed and breakfast utilized above a garage on the subject property. And staff recommends approval of the extension of conditional use permit 21-04 with conditions. Agenda item number 11 is conditional use permit review 21-25 for Jessica Hessler, Seven Wonders LLC, to review a vacation home rental on the subject property. And staff recommends approval of the extension of conditional use permit 21-25 with conditions. Agenda item number 12 is conditional use permit review 21-56 for Alex and Holly Neiman, operating under ANH Enterprises, Inc., to review the rental of 36 UTVs, 6 slingshots, to include a washing area, parking area, and 36 to 40 employees. Staff recommends approval of the extension of conditional use permit 21-56 with conditions. Agenda item number 13 is conditional use permit review 22-11 for Justin Kistler to review living in an existing double-wide mobile home while building a single-family residence. And staff recommends to end conditional use permit 22-11 with the applicant's concurrence. Agenda item number 14 is conditional use permit review 22-09 for David and Mary Grover to live in a pole barn slash shop building while building a single-family residence on the subject property. And staff recommends approval of the extension of conditional use permit 22-09 with conditions. Agenda item number 15 is planned unit development overlay review 22-04 for John and Tracy Wiebe to review a specialty resort including 3 tent spots, 1 treehouse with living quarters, and a caretaker slash manager residence on the subject property. And staff recommends to approve the extension of planned unit development overlay 22-04 with conditions. And lastly, agenda item number 16 is mining permit review 14-02 for the Pennington County Highway Department to review the excavation and extraction of gravel. And staff recommends the approval of the extension of mining permit 14-02 with conditions.
Thank you, Jason. Any items that the staff would like to have pulled at this time?
No, sir.
Commission, is there any items that you would like to have pulled at this time?
4 and 16.
4 and 16?
16.
16, 1-6. Any other items from our members? Anyone in the audience that'd like to have one of those items, 3 through 16, pulled at this time? That's here to speak on one of those items. Very good. Let's go to number 4.
We have to have approval of the consent.
Oh, excuse me,
Yeah.
yeah, that's right. I apologize. That's why I write number 3 on here, Jerry, so that I know to do that. Okay, we got the polls done. We need a motion, please, to approve the consent calendar.
Mr. Chair,
Yes.
move to approve consent agenda items 3, 4, or 3, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, and 15.
Second.
Moved and seconded to approve the consent calendars with items, actually number 4, number 16 pulled. Does that work with the motion maker?
Sure.
Thank you. Discussion?
You don't like to say all those numbers?
No. Discussion? Hearing none, all in favor of the motion signify by saying aye.
Aye.
All right. Opposed? Motion carried. Now we can go on to number 4. Thank you.
Mr. Chair, number 4, I make a motion that we waive the rules on number 4, which also relate to number 9 and 11.
Is there a second to that motion?
Second.
It's been moved and seconded to waive the rules so that we can discuss number 4 and do it properly. There's an error in number 4 that I wish to bring up, and number 9 and number 11 may or may not have that same error, and we want to make sure we address that and have it cleaned up for the record before it's recorded so the commission knows what we're doing. Any other discussion on that? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. Item number 4 is a simple one. If you want, you don't have to go very far. Let me flip to it here. And what it is, it's the contact person. I don't believe Leanne McDowell, it's on the first page, page 1 of 7. It should be in there. And then
That is
I have
correct,
the
too.
same questions about number 9 and 11 to make sure that we have it correct for the record. TJ, am I right there? It looked to me like in your conditions, it should be executive lodging of the Black Hills.
Yes, you are correct. That needs to be changed on the front
Okay,
page. Yes,
because
that
Leanne McDonald does come up in our later,
yeah,
and I didn't
she's-
want her confused on
She's no
that.
longer the contact. They have updated that, so yeah, you are correct.
All right, how about number 9 then? Who's the planner for that? So that we are allowed to discuss that now. Who's ever the planner for number 9, please? Let's make sure we have these contacts correct. I think it's Kelsey? Yeah. Are you on number 11 too?
Yep, 9 and 11.
Okay. Would we be correct in what contact person should we have there for the record?
It should be Executive Lodging in the Black Hills by Vacasa.
For both? All right.
Yep.
Very good. That's my question. Chair to address a motion to approve number 4. Go ahead.
So
Number
moved.
4. Is there a second? All right. Moved and seconded to approve number 4 with the correction of the local contact person. Discussion. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. Number 16. We're going to go to number 16 next.
Simple question. The annual reports show there's no mining. Is that an inactive mine at this point?
I don't believe that it's inactive. I believe they just, whenever they need it, they open it and use it, and that's why they want to keep the conditional use permit in effect.
So there's
Mining
two
permit.
separate sets of property on this, the two pits, by the looks of this thing. Do they just crush on one and haul from the other one?
That I would have to ask County Highway. I'm not 100% familiar with this request. This was Cody's staff report, so honestly, I can get you that answer.
Because it's, like I say, it's a fair distance apart. That's why I wondered how they did that.
Right, yeah, if you'd like to continue the item to the next meeting, we can do that as well.
It's not that important. I was just curious. I could find out.
Sure.
That's all I had, Mr. Chair, just those two.
Okay. Would you care to make a motion to approve that?
I would so move to make a motion to permit, to accept the mining permit 1402.
Second?
Moved and seconded to approve per staff's recommendation, mining permit 14-02. Discussion. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. I believe we're on to item number 17 then. All right, go ahead. Go ahead, Megan.
Megan Talmadge, planner. Agenda item number 17 is conditional use permit CU 23-11 to allow a vacation home rental on the subject property. The applicant is Saddle Properties, agent is Stacy Kuehl, and the local contact is Laura Huber. The lot size is 1.54 acres, and the current zoning is suburban residential district. The zoning ordinance lists 7 criteria when considering conditional use permits. They are listed on the screen. And this item was continued from the April 24th, 2023 Planning Commission meeting. Staff has received multiple concerns from the neighbors, and they are attached. A site visit was performed, and there were smoke detectors in each bedroom and a fire extinguisher on each floor. And so staff recommends to approve conditional use permit 23-11 with 15 conditions.
Okay. Thank you. Questions for Megan? I guess you're going to get to sit down for a while. We have a number of requests to speak on this item, and we'll start through those, and then we'll address. First one, I've got Larry Luchsinger? Luchsinger. All right. Thank you, Larry. If you please come up and introduce yourself for the record, and then go ahead and go from there.
Larry Luxinger, and I live in the property that adjoins Stacy property just to the east. I also presented at the 24th meeting that was postponed and brought up several concerns at that. And I included, the chair asked me to include the findings of fact from the 7th Judicial Circuit Court and from the South Dakota Supreme Court concerning the other vacation property, and I did include that in your packets. I hope you had time to read that. We thought, the neighborhood thought it would be good, since that, we don't get that criteria, none of the neighbors get that. And so we thought, well, we should probably have some input into that as well. So we did make copies of those things. Some of those criteria don't really apply to us, some of them do. I addressed criteria number 1, the established maintenance or operation of a conditional use will not endanger public health, safety, or general welfare of the neighborhood. Sandquist Lane is a dead-end street which does not include an egress exit to its west end. There are currently 16 developed single-family residences along Sandquist Lane, Plume Drive, and Forest Road to the west, with an additional 2 to 3 lots that are still available for development. We all know that live there know that the nearest egress in case of an emergency is the intersection of the west end of Forest Road and Highway 44 at Johnson Siding. In addition, that's about a quarter mile from where I live. At Johnson Siding. There is an additional 65 single-family residences located along Forest Road, Cliffview, and Mission Hills Loop to the east of us. The closest emergency egress of approximately 1/2 of these residences is also at that intersection at Johnson Siding. In other words, in the case of an emergency, approximately 40 families would be forced to use the one available egress at Johnson Siding. Another 40 families would be forced to use the only remaining exit at the east end of Forest Road and the intersection of Highway 44. All this congestion would be occurring simultaneously with necessary emergency vehicles attempting to enter the neighborhood to address the emergency situation. Should this permit be approved and including the vacation rental property approved to our south, we are looking at a potential of an additional 12 vehicles, which would be required to use our only available exit. Add in the fact that many of these short-term renters bring trailers with motorcycles, ATVs, and boats, and you have a bad situation which has now become much worse. If an emergency situation arises to our east, we all know that in order to get out, we have to run towards the danger. If you have up to legally allowed 24 individuals, not to mention those who are there illegally, should God forbid see smoke and fire rising over Mission Hills Ridge to the east, their natural tendency would be to head away from the threat to head to the west. If this should occur, 3, if not possibly 4 families from the neighborhood would be boxed in at the west end of Forest Road, where there is no exit. If any of these people had a trailer attached, there's no turnaround available at the west end of Forest Road. They would be required to back up their vehicle and trailer the entire length of Sandquist Lane in order to access and turn around so that they could head east towards our only available exit. Email was sent from Jerome Harvey. Jerome Harvey states, and this is pertaining to what is currently a shared driveway. Driveway is gravel and creates some issues for access, but nothing that would prevent the response under normal conditions. The big issue is for evacuation on the dead-end road with emergency vehicles responding in and evacuees traffic attempting to leave. So that is a concern. The establishment, again, this is related to criteria number one. It is difficult, if not impossible, for vacation home rentals to appropriately vet who they are renting to. We can only tell you from personal experience that some of the individuals who have rented that property to the south of us are not individuals that you would welcome into your neighborhood. At the April 24th meeting, I listed concerns that we have already experienced. On numerous occasions, violations have occurred on this property and nothing ever seems to be done. Violations and nuisances include excessive noise in and outside of quiet time, the number of occupants at the vacation home, the number of vehicles that are parked have all been violated, motorcycles with additional occupants next to the property and staying in the motorhome, fifth wheels with additional occupants next to the vacation rental and staying in the fifth wheel. We've had litter trespassing, individuals urinating in the driveway. We've had tents, intoxication, lights being shined in our windows, and pets, which are not allowed, barking dogs on numerous occasions. The most recent incident happened just this past Thursday. There were 5 individuals staying at the rental. The rental has a capacity of 4. I'm working in my front yard, approximately 80 feet from 3 males, 2 females that were just in. If you can pull up that picture, the other one of the Hammerquist or R3 properties.
We'll get Megan to do that just a moment.
There were 5 individuals.
Thank you, Megan.
If you can see my place, 13046, Sonquist 13049. I'm in where it says Sonquist Lane. That's about where those vehicles were parked, just barely off the street. 5 individuals were there. The rental allows for 4. They're all in camo. They've been there chirping turkey calls and gobbling, which annoyed me enough since I was working in the yard. But I'm between my front door, which is where that icon for 13046 is, and the street. One of these guys pulls a shotgun out of the back of his pickup, and he starts cycling rounds. He's holding his gun like this, cycling rounds through this 12-gauge shotgun. Bolts are kicking out. I'm standing from a little more than this wall to that wall in my yard. He discharges over my head, missed the corner of our house. I imagine it impacted somewhere over across Highway 44 on Pine Cliff. The sheriffs were called. These guys bailed into their pickups out of there. Sheriff Dave Olson came up and interviewed. He assumed that we would never see these guys again. But he said if they do show up to try to get their license plate number, contact the sheriff's department, and some additional deputies would come up and intervene. After dark, we hear a vehicle pull in. We look over, it's too dark. We know it's a pickup truck, and then a second one comes in. We know it's the 2 pickup trucks. Too dark to see the license plates. The sheriff's department is called. They show up. Well, I got to tell you this. I contacted, this happened at 4:45. Immediately when it happened, I called the planning department. And we had an incident 3 years ago, and I haven't spoken to the Hammerquist since. So I had no contact number. So I called the planning department and said, hey, this just happened. And I was told, well, if weapons are involved, you need to call the sheriff's department, which we had already done. And I said, can you give me, you guys must have a list of the local contact people, because I was going to call Hammerquist and say, hey, the law enforcement's involved here. This is what this idiot just did. And I was told to go on Google, type in the Hammerquist property address and vacation home rentals, and that there should be a contact number there. There wasn't. There wasn't a contact number there. I called back and said, there is no contact number. Dwayne gave me that number, and I have the floor here. Okay. Dwayne gave me that number, and we were able to contact Hammerquist. Hammerquist had no idea who was staying there, what their names were, what their license numbers were. And when I go into a motel, I have to give them all that information. They didn't have any of that. Anyway, the two officers came back later. They rolled up, darked out, parked by us, went up to the Hammerquist cabin, flashlights on, went in, interviewed these guys for 45 minutes, maybe an hour. The next day, nobody got back to me. The next day, Officer Dave Olson, who did the initial investigation, contacted me and said, these guys blew smoke up those two additional officers, said the gun was jammed, they were attempting to remove the jam, and the gun misfired, or accidentally discharged. So they didn't get charged with anything. Hammerquist had texted me and said they'll be evicted immediately. They were there for the next two.
Can I ask you a question? Because you kind of combined two, there was another incident or something, you lost me on something, just the one.
When Officer Olson
Right.
showed up, these
But you
guys
said
had already,
that a while back, there was another incident that you had
3 years
Googled
ago.
or something.
No, when I called the planning department to get the contact, so I was gonna also.
For this
inform-
discharge.
For this discharge.
Okay. I got lost on that.
Yeah, and so, anyway, Officer Olson, who did the initial interview and investigation, called me on Saturday, said the officers spent about an hour with these 5 individuals who are staying at a cabin that's approved for 4, and they blew a bunch of smoke about the gun. You can't jam a gun and still be cycling rounds through the gun. And so they weren't charged with anything. Officer Olson still says it was still a reckless discharge of a firearm, whether it was jammed or not. They should have been charged with that. Hammerquist could not evict them because they go through this company called Evolve. And Evolve said it wasn't a serious enough offense to have them evicted. So that's just an additional incident. I don't think that provides harmony to the neighborhood when you have stuff like these things happening. That's just one of many. Did you have something to say?
Jason?
Yeah, I just
Were
wanted
you
to-
on the contact?
Yeah, I just wanted to speak to that local contact on Thursday. Dwayne did let me know that you had called the office and that he had told you to look online and see if you could find the local contact information there, because he didn't have it readily available. So
He didn't tell me that.
in the meantime, he went back and he did research, and I believe he did provide you that local contact
On
number.
my second call, he did.
Okay, yeah,
Yeah.
because he didn't have that readily available.
And I also mentioned, Dwayne, I said, law enforcement is dealing with the part of this that was the discharge of the firearm that went over my head.
Right.
I said, but there's 5 individuals and there's only supposed to be 4. That's your guys' problem.
Yeah,
And
typically-
Dwayne said, I'll make note of it and talk to the director.
Right, yeah,
I
and
have heard
typically,
nothing about it.
yeah, and typically when that happens, we let the local contact handle that situation. And if they don't, then at that point, we'll go out there and make note of it. So, but if there's any kind of discharge of firearms, the planning department is not going to respond because we're not equipped for that.
I understand it's a scary situation.
Right.
Mr. Chair,
Yes.
and I just requested for the sheriff's report and everything from Jerry so that we can look into that. There is a process that happens whenever there's a negligent discharge firearm. And so I want to verify and see what they did in that process, because I know what that process is when you have a negligent firearm discharge. Typically, they will take the weapon and hold it to verify whether or not there's been reported vehicle damage, housing damage, or something when there's a negligent discharge. And I know that for a fact because I have a friend who had that happen. Sheriff's Department came, They verified that there was no damage at that time. They confiscated his weapon at that moment for about 2 weeks. Nothing was reported, and then they returned his weapon. He was never cited. And he shot a big caliber rifle because it was jammed as well. So I've asked to see that report so we can look into that so I can verify.
A big caliber rifle or 12 gauge shotgun from 80 feet. It's gonna do some damage, you know. Dispatch gave me 2 case numbers. Officer Olson, when he contacted me back and said these guys blew smoke up the other officers, they were counseled, and nothing was done. They weren't charged with anything. So
If you have those case numbers, I'd ask that you give them to Jerry so she can let them know.
I don't
whoever
have
she-
them with me, but I have them written down at home.
Thank you. I concur. I was going to ask for the report too. Is that something that we've got to do a motion on? Do you think, you guys, do you feel comfortable without a motion on it? To
Just
have
getting the
report?
information. It's like if we ask information on anything else. You just
They're
wait.
allowed to file it. I just wanted to make sure the commission was comfortable with it. Thank you. Go ahead, Larry.
So going back to 40 people having to use the one exit at Johnson Siding, across from Johnson Siding, the additional 40 people using the exit at the intersection of Forest Road, the east intersection of Forest Road and Highway 44. Jerome Harvey states that's the big issue for the evacuation of the dead-end road. Emergency traffic responding in and evacuating traffic leaving.
Sir, could you identify Jerome Harvey for the record?
He's the Pennington County Fire Marshal, isn't he?
Yes.
Yeah, okay.
I just wanted that for the record so that people are aware of
I thought you
who it
know
is you're
that,
talking
Kevin.
about. I'm aware of that, but we want to make sure we put it in the record.
Okay, thank you. Criteria number 2, the uses and values and enjoyment of the properties in the neighborhood for purposes already permitted may not in any foreseeable manner be impaired or diminished by establishment, maintenance, or operation of the conditional use. I will simply quote the Seventh Circuit Court statements in their findings of facts related to the vacation home property in the subdivision to our south.
Larry, I got a question that it doesn't relate to vacation home rental. I read the whole thing, it relates to multi-dwelling.
Yes, sir.
Yeah, it does relate to a two-family.
Multi-dwelling, that's a different
I told you that.
configuration of housing
I told you that.
under our law and under the state law.
I told you that.
But
At the meeting on the 24th.
Then what I'm saying, the facts and findings don't apply to this. This is a vacation home rental, not a multi-dwelling.
Okay.
Multifamily.
Multi-family,
What
yeah.
they say is this is how renting affects the neighborhood. Renting.
That is renting, and it's long-term renting, multi-family dwelling. That's a different ordinance, it's a different state category, everything, Larry.
Can I quote what the Seventh Circuit Court says about renting?
I think you're spinning our wheels by doing that. We have other people that like to speak
Isn't this
too.
renting?
We don't correct you as far as time, but there does get to be a point where we can't review that. That isn't acceptable material.
I'm going to review that.
Yes, you are. You're giving testimony, Larry.
I'm not asking you to review Hammerquist. I'm asking you to listen to what the court opinion was on how renting impacts the neighborhood.
Multi-family dwelling has nothing to do with the vacation home rental. I'm
I will-
sorry
I
that
will- I
upset you.
will- Will not mention multifamily renting. I will mention renting.
As a courtesy, I'm going to let you do it, but I don't want to hear any more about the findings, in fact, when it involves a different ordinance, a different entire area of our ordinance structure and the state structure. That's why the courts looked at it that
Involves
way.
an impact on a neighborhood.
That's normal renting. It doesn't involve this particular vacation home renting,
Okay, can I talk about normal renting in the neighborhood?
I
And
guess.
what the Seventh Circuit Court feels about that?
I said you may go ahead and do that.
I will simply quote somebody related to renting of properties, not renting provides a benefit to the property owners by maintaining the residential character of the neighborhood and contributing to the enhancement of quality of life in this historic and scenic area.
Mr. Chair,
Yes.
where's that at so I can follow along? I just want to know where it's at so I
In
can,
your packet.
I understand that. What page is that in our packet?
Oh, I don't know.
What
It's
categorization of that court order? What designation in that court order? I've got the court order in front of me that you're,
findings of facts.
okay, but on yours, is it like item number 9? Is it 10, 12, 15?
I'm sorry, sir, I didn't note that.
Is there, you don't have the court in front of you? You wrote it
No,
down?
I just typed this up and didn't bring that form.
Okay.
I apologize. Somebody said renting to a third party had an adverse effect on the value of property. In addition, it had an adverse effect on the quality of life and the general scenic and tranquil environment in which we live. Such an adverse effect on the quality of life and scenic and tranquil nature of the neighborhood cannot be adequately compensated by money damages. Criteria number 3, the establishment of the conditional use will not impede the normal or orderly development of surrounding properties for the uses permitted in this district. When you look at the first line of the county ordinance section 209-SR suburban residential district, it states, a suburban residential district establishes areas that provide for a suburban lifestyle within a single-family community. Pennington County's ordinance definition of a vacation home rental is a dwelling that is rented, leased, or furnished in its entirety for the public on a daily or weekly basis for more than 13 days in a calendar year, and not occupied by an owner or managed during the time of rental. By definition, those two definitions contradict, and by definition, the vacation home rental contradicts the normal and orderly development of surrounding properties in the neighborhood. In the normal development of suburban residential single-family neighborhoods, the neighbors know their neighbors, which adds a layer of protection to the neighborhood. The influx of temporary vetted or unvetted transient guests to the neighborhood will remove the normal sense of security and comfort that individuals living in the neighborhood have come to expect and enjoy. Individuals looking to retire in a safe neighborly neighborhood, particularly those of retirement age or families with young children, will certainly consider the nature of the safety of the neighborhood before deciding to buy or relocate. 20 years as a residential real estate appraiser has shown me that when a portion of the market considers a neighborhood as undesirable or less desirable, values within that neighborhood will suffer. Yes, the establishment of a conditional use will certainly impede the normal and orderly development of the surrounding properties. Adequate utility, criteria number 4, adequate utilities, access, drainage, and other necessary site improvements. Sandquist Lane is a narrow 22-foot road which does not include the typical 66-foot right-of-way easement typical of most roads. On Sandquist Lane, once you leave the surface of the road, you are trespassing. South Dakota Codified Law 31-3-1, Shippey versus Hullapeter, and Scherer versus Huttershire, Bruder, and Jammer Road. In addition to access the proposed rental property, the renter would be using a private drive designated for the use of lots 2 and after lot alignment, lots 3 and 4. On July 10th, 1984, when the owner of the dominant estate, Clarence Gusler, and this is not in your notes, I kind of screwed up this whole section when I wrote, but anyway, on July 10th, 1994, when the owner of the dominant estate, who subdivided the property, conveyed ownership to Shaldak. I can't remember Shaldak's first name, it was a strange one. In a warranty deed, he did not convey the private easement for private drive and public utilities. That was in the warranty recorded on June 10th, 1984. Criteria number 5, adequate measures have been and will be taken to provide ingress and egress as designed to minimize congestion. And again, Sonnenquist Lane is a 22-foot road with no 66-foot right-of-way easement. And I've included that rule or the letter between my attorney and, at the time, I think it was Ron Buskerud. Thank
Chair.
you. Any questions?
Secondly, questions for Larry?
Brittany or Jason, I got a question for you. And I don't see Megan, our lawyer, here, so that's the only reason
Is
why.
it something that,
It
in regards
is
to
about-
Larry's testimony?
It is about his
Thank you.
testimony. That's why I want to get clarification. Did anybody get a chance to read that court ruling?
I did not personally. I don't know if Megan did. Megan actually is at hearings this morning. She may be here later.
Gotcha. Second question I have is, this current property, is it being requested to have a multifamily in it, or is it just a VHR, Airbnb, or whatever it is?
My understanding is it's just a vacation home rental.
So then my understanding in reading this, specifically out of the court case, is that the plaintiffs have satisfactorily shown that they are entitled to a permanent injunction permanently enjoining the defendant from utilizing his residence as a two-family dwelling. So as I read through that entire court case, it's dealing with as a two-family dwelling. A VHR is not a two-family dwelling, so it would not apply to that. Is that correct?
We do not consider a vacation home rental a two-family dwelling.
Gotcha.
It says, because of the use, it's used by one family
family.
in its entirety.
Gotcha. I just want to make sure that we're all aware that this very specifically states it's a two-family dwelling, has nothing to do with, rentals in that aspect. It was only because it was utilized as a two-family dwelling. And it was very specifically stated in 33 of that court case, the defendant's conduct in renting a portion of the property to a third party had an adverse effect of the value of the plaintiff's property. So it was really dealing with that very specific, the person lived there and was renting a portion of his own dwelling to somebody else, not in the case what we have VHRs for.
So when we look at multifamily dwellings, they're two families that live completely independently of each other within the same structure.
Yep, just want to make sure that that's defined out there so the public understands
Yeah,
that.
and I can't make inference to what the court case says. I can just tell you what our ordinances define.
Starts like right
Gotcha,
after.
thank
All
you.
right, thanks.
Could I respond to that?
Sure. Well, actually, it's the chair's choice, it's not mine. I'm sorry, I said sure, but it's really the chair's.
Wow.
Oops. Charlie, he asked a question if he can respond.
I just wanted to
Sure,
respond to.
go right ahead, Larry. I apologize.
That's fine, that's
Damn
fine.
it, two questions at the same time.
If you continue to read that, and I did inform you guys at the 24th meeting that that's what that was dealing with, was a two-family. But if you continue to read that report, if you closely read that report, and that findings and facts, and it may be in the Supreme Court's section of that the residences within that subdivision, it doesn't say two-family, it doesn't say one family, it doesn't say, what it says is cannot be rented for commercial purposes. Now, when you talk to the Department of Revenue for the state of South Dakota, I know you guys somehow have a different definition for single-family residence. But the Department of Revenue considers them to be a private for-profit venture. That's why they can be taxed, same as a hotel or a motel. In that report, it says they cannot be rented for commercial purposes. Doesn't matter, one family, two family, whatever. So, and I apologize if there's confusion about that, but I clearly stated that at the 24th meeting.
Mr. Chair,
Yes.
I think it would be appropriate if Megan's willing to clarify that on the commercial versus residential, and what the state's position is, because as far as I understand, unless something's changed, the state's position is that VHRs are residential use. Is that correct?
Can we wait for that? There are a number of other speakers, and maybe we'll have additional questions on that. Travis, would you be comfortable with that? And
That's
give
fine.
her
I
a
just
chance to look at what's being addressed here.
gotcha.
I got a question. I hope I'm not being redundant and brought it up last time. Are you aware that South Dakota law allows 14 days of short-term rental,
Yeah, I think,
irregardless our ordinance, your thoughts, or anything else?
oh,
You
yeah,
know,
absolutely. I think that was
okay.
primarily due to the rally,
Mhm.
why that law was, why that originated.
You know, I thought so too until I found out that it involved hunting in other counties. It involved lake property back
Oh,
east. So I had a misnomer in that too. I thought it just involved the rally when I first brought up. But there's a lot of vacation home rental style type things, the short-term rental done under the 14 days for other things
yeah.
than the rally.
And I thought that was a good thing too, because in the meeting on the 24th, Stacy said, his primary purpose, his friends and family wouldn't stay there because they didn't feel right about it, and they should have to pay for it and so on and so forth. And I thought, well, Stacy, one, if I stay at a friend's cabin and they allow me to do that, I make a donation when I leave. Two, if it's just friends and family, they can stay there. You can rent it for 14 days every year, So maybe that will meet his needs. I'm not sure.
Okay, and then my second question would be, are you also aware that the same Supreme Court that wrote the opinion, different members, I'm sure, in that you submitted to us in regards to the multifamily dwelling, they've decided that the use of the property is not based upon commercial or whatever. It's the same basic use, which is residential, and they don't address that, as far as I know, the commercial in there. In fact, they kind of tell you to look otherwise if it isn't
Yeah,
in covenants and whatnot. Are you aware of that?
yeah. And I am very aware of that. And what the
Okay,
Supreme Court did is they ruled on the occupants of that dwelling. How are they using that dwelling? That's what they ruled on. They're using it to sleep. They're using it to watch TV. They're using it to cook. They're using it to barbecue. Their use of that dwelling is single family. They didn't rule on the purpose of the dwelling from the property owner's perspective. The property owner is using it as a private, commercial, income producing venture. They didn't rule on that. Since they didn't rule on that, the Department of Revenue can tax them. They ruled on what are they doing when they're in the
okay,
property?
but I think we're leaving one thing out, and I'm not going to talk about what they ruled or didn't rule on, but it did involve a vacation home rental,
Yep,
correct?
yep, and I totally
And they
agree.
ruled that the use was, in fact, residential.
I totally
And,
agree with them.
okay,
When people are there, they're
all
using it
right,
as residential.
thank you. That's
The property
all.
owner is using it for something different.
I just wanted to make sure that you were aware that that case is involved here too, and we
Yep,
hear
that was
about
in
that
Lawrence
case.
County,
Okay.
and that's what you guys apparently follow.
Any
So,
other questions for Larry? Thank you, Larry.
thank you.
Julie Brooks.
Good morning.
Good morning. Please introduce yourself, just for the record.
Got it. Julie Brooks. And I am not a public speaker and have never been in a meeting like this before, so bear with me. I get a little nervous. I'm also addressing the criteria for evaluating conditional use application. Condition or criteria number one, the establishment, maintenance, or operation of the conditional use will not be detrimental to or endanger public health, safety, or general welfare. The guideline given is explain how the proposed land use will fit into the neighborhood. The checklist that Mr. Cudel filled out stated that no, nothing related to his commercial rental business or transient renters would be detrimental to us or those living in the neighborhood or impair our general welfare or safety. And then the guidance goes on to say if there's going to be lighting, noise, outdoor storage, excuse me, traffic or other outside activities, explain how the activities will be limited to a reasonable level. And I didn't see anywhere where he had addressed that. Maybe he did somewhere else, but I have not seen how he addresses the guidelines. But by their nature, commercial temporary renters do not fit into a neighborhood. They aren't like regular neighbors that you know, wave to, or take care of your cats when you're gone. They don't let you know when someone is trespassing on your property or when they hear the sound of a burst pipe in your lower level across the street and shut off the water for you. They are unvetted, transient strangers. They have no desire to or investment in getting to know you. They are temporary. They are detrimental to the character and cohesion of this neighborhood for those reasons. And it also talked about lights, lighting, noise, vehicle lights entering and leaving at night, shining through our bedroom window, reminding you that we share or we both use a private driveway. So his property and ours are very close from the driveway. And I do have some questions for Stacy, and I understand that happens at the end of this. Is that correct?
Yes.
Okay.
We usually, we allow the applicant or their contact person.
Okay.
We ask them to come up. They don't fill out a speaker form because they are the applicant.
Right, okay.
Thank you.
Regarding noise and traffic, reminding all of us that these renters don't just come and stay in the home. They're here to visit the Black Hills. And so they come and go multiple times each day and evening. They may leave early in the morning to visit Mount Rushmore or go to the Badlands, come back to regroup and rest, run to town for additional groceries or a meal, leave again to eat at a Mexican restaurant just down the road from us. Later, they might drive to Crazy Horse to watch the evening light show. So, I'm reminding you again of the number of renters that are possible at his dwelling, 8 full-time or overnight and 8 additional day guests if this is a family reunion, which are real common in these vacation rentals. Multiple guests driving from 4 to 8 vehicles could be leaving in different directions to tour the hills, coming and going down the private shared driveway or private driveway at different hours of the day and night would definitely be a disturbance and a detriment to our peace, quiet, and privacy, and as well as to the wildlife in the area. Additionally, after each guest leaves, the cleaning person will come and go. A lawn maintenance person or crew will come and go to maintain the lawn or possibly snow removal, adding additional traffic, lights, and noise. And also, this is a small dead-end street of 7 homes. All but 2 are retired people. And it's always been a retirement little dead-end road. There's only been 2 families. There's one currently with a small son and some people, boy, almost 10 years ago that occupied a house that's not even there anymore, and they had small kids. But other than that, there's never been kids. I've lived there 40 years, and I had 1 trick-or-treater. And I was so shocked I didn't even have candy in the house because no one comes. Let's see, a total of 8 to 16 adults, plus any children and their vehicles, trailers, etc., plus cleaning and lawn care personnel could substantially impair and be a detriment to the peace and quiet of our neighborhood. And this could also adversely affect the population of wildlife that freely roams through the neighborhood. We currently have nesting geese, nesting mallard ducks, deer, great blue herons, and turkeys that we cherish. Criteria 2, the uses, values, and enjoyment of other property in the neighborhood for purposes already permitted may not be in any foreseeable manner substantially impaired or diminished by establishment, maintenance, or operation of the conditional use. And the guideline states that he is to explain how it will fit into the neighborhood, what will be done to avoid potential nuisances, such as limiting the hour of operation, noise control measures, adequate parking, paving the parking area, etc. And I'm assuming that he will address those things on the guideline. And I wrote, a definition of a nuisance is causing inconvenience or annoyance. And I think these concerns are far larger than an inconvenience or an annoyance. Temporary renters leaving at 6 a.m., arriving late at night, and even when, I can tell you this, even when they say quiet hours are from 7 or 6, whatever they say, people always leave early. They want to get on the road, and they don't abide by that. So car doors opening, closing, lights, people loading, conversations, and people do arrive late at night. So it doesn't matter if that's stated, people do it anyway. It can be a disturbance, definitely, when it disrupts and impairs our sleep. And then I have additional questions for Stacy. And I have questions for the planning committee, but I don't know when I'm supposed to ask those questions.
That's what you're doing right now, Steve.
Right now? Okay.
Right now, Julie.
So, and some of the rest of my paperwork here does address the problems that we've already had with Mr. Kudel when he was renting his property long-term. And they were severe. And these issues took forever to be resolved. And we weren't listened to, and so it was a really, really bad situation. So my question is, if we have issues and they are dismissed or aren't responded to, is there recourse for us through the county? Hi, Megan.
So we do have a complaint process that you can follow through with.
Okay, I did look
And-
that up.
Yep,
Uh-huh.
and I believe I sent you the link to that, right?
Yes.
Okay.
You did.
So you would follow that complaint process, and we would send out our code enforcement officer to ensure that it is a complaint regarding the VHR, that it is valid, and then we would start the violation process with him.
Okay. And so, is that a lengthy process? Does that?
It is, yes.
It is. Is that something that gets attended to soon?
Yeah, the timeline, well,
I'm thinking that there could be a number of people with concerns and complaints,
Yes.
and maybe not very many of these compliance people.
since I am not the code enforcement officer, I can't exactly speak to a timeline that would be followed.
Okay. That's fine.
Okay.
Yeah,
Mr.
and I
Chair.
did look at that, and, but I just really wasn't real clear on what, with this, like, when people do complain or have concerns about ordinances that aren't being followed.
If you don't mind, Megan Kruger with the state's attorney's office. So our complaint process is somebody makes a complaint, essentially. Then Dwayne goes out and verifies whether it is true or not. Then he sends a letter that is required by both our ordinance and by state statute. You have to give somebody due process and opportunity to fix the problem. And then if they don't fix the problem, there are three options, well, four options with this. They can have their CUP revoked. There is a process by which that has to be done. And you have to follow certain statutory guidelines. All of this does take time. None of it is immediate because people have to be afforded due process. You can't just take things away without hearing and the right to be heard and so on and so forth. And then the other option is I can charge them with a criminal violation. We don't do that very often because typically that's one of the most, I guess, horrible things that you can do to somebody. And then the other option is suing them. We can't really abate these because abating assumes that you can actually go out and fix the problem. The abatement in most of these cases would be removal of the CUP. So.
Okay, thank you for that. I
Yep.
appreciate that. And I
Travis?
guess,
Excuse
regarding
me.
that,
Excuse me,
oh, I'm sorry.
Julie. Travis, you had.
All I was going to point out is if there's someone who's violating the law, such as trespassing, you need to call the sheriff's office for that or the
Oh,
local
sure.
police, because anything that's a violation of the law, then you need to make sure that they do their investigation. And again, that can take some time because they'll go and do their investigation, and then depending on the outcome of that, you may not know, okay, was it somebody from the VHR or was it just some local individual that was trespassing?
True.
Yeah, and if I can just follow up with that. So the former gentleman that had indicated that there may have been a crime committed, really, if there's a crime being committed, you guys need to contact law enforcement. Because the planning commission or the planning department is only available 8 to 5, really Monday through Friday. And not even really Fridays now because we're on a completely different schedule.
Right.
So if there's a crime being committed, you need to contact law enforcement. That's
And we did do that, and, but what we wanted also to do was to inform the committee that, these were some issues, and thought they should be aware, and so that's why we did contact the county about this issue. And I guess, when my thinking on this was, Stacy has stated that he's only going to be renting to friends and family. My concern is with issues, is he going to have the same objectivity with friends and family as he would if it were just a renter, person he did not know? Would he be more likely to dismiss or be skeptical when it's his family? And I know nothing that you can have a say really anything about, but it's very definitely my concern that it won't be heard. So, okay, you answered my questions about the process, and I appreciate that. Let's see. And as far as violations that, the CUP can be revoked, so that is good to know. Criteria to continue, the uses, values, and enjoyment of other property in the neighborhood for purposes already permitted may not be in any foreseeable manner substantially impaired or diminished by establishment, maintenance, or operation of the conditional use. The regulation states that in his posted rules for the proposed CUP, it must say that renters must be courteous to all neighbors and respect property boundaries. Even though his rules stated the boundaries, and it's very clear what his boundaries are to the creek, and he pointed all of that out. But when he had renters there the last weekend of April, before he had the conditional use, we watched people walk from his property right across to the Whitnable's property and then onto the bridge, which adjoins their property, and that's owned by Kathleen and Alex Olson. We were just taking our walk, and we watched them. We watched the three people from Stacy's property go on the bridge, start jumping up and down. And as with anybody on our neighbor's property, they look out for us. We look out for them, as good neighbors do. And so we said, "Are you from here?" Or, we hadn't even seen their cars. And they said, yeah, they were here for their grandmother's funeral. Their grandmother had owned the house prior to Stacy, and they said that Stacy had rented it to them. And he was kind enough to do that so that they could be there for the funeral. We didn't even ask if they were renting. That's what they said. So they immediately trespassed, in spite of all the guidance that he had in his posted information for his guests. In terms of nuisance, trespass is not a nuisance, an annoyance, or being discourteous. It's against the law. It impairs our privacy, diminishes the enjoyment of our property and neighboring properties. When I visited, and in my paperwork, I said that he offered to rent. What was actually said, and that was my error, was that he did rent to them. That's what they told us. Stacy told me that he always follows the rules when he or they stay at a vacation home rental. And my response to him, not everybody does. When there is an absentee landlord, people will sneak pets in, they will smoke, invite additional friends, be louder than they might be otherwise, litter, and clearly trespass. His response was that he has a camera system that monitors his entire property at all times. And that may be fine for the people on his property, but that doesn't address the people that trespass. We have had our share of trespassers. We have not fenced our property because we don't want our view obstructed by a fence. And because we don't want to impede the flow of wildlife in the area. Wildlife travels through, and we don't want to do that. We have allowed people to fish on our property as long as they ask, don't litter, or bother the wildlife. Neighbors have asked permission to swim their dogs or walk on our property across the creek, and we allow this because they ask. And because we know them, we will report all trespassers. That the conditional use will conform to all applicable regulations of which it is located. And the guideline states, review the current zoning districts to ensure your project is compliant and in harmony with current land use guidelines. Well, a definition of harmony is concord or agreement in facts, opinions, manners, interests, as good citizens live in harmony. We are zoned as suburban residential, not commercial. And I know Larry already talked about the difference as in for-profit commercial use versus residential use, but it's very confusing to us when two departments say two different things. But I can say that we, the people, neighbors most directly impacted by the proposed CUP are definitely not in harmony with the proposed commercial use for transient renters directly across from us, utilizing a private driveway. I've also got responses to section 319 of the ordinance. And the most important part of this ordinance is that it does not address the number of VHRs allowed in Pennington County. I'm sure this is under discussion because of the vast numbers of them coming through. I understand that there's no current cap on the number of VHRs in Pennington County, and that there is discussion looking into maybe a cap of 5% for all of unincorporated Pennington County. Where my fear lies is I'm unaware of whether the county will apply this cap regardless of where these homes are located or how they will apply that cap, such as our neighborhood of only 7 homes on a dead-end street. Currently, all homes besides ours could be approved for a VHR, the way the
Mr.
rules
Chair?
are.
Yes.
I'm going to suggest if you want to discuss what's going to go in the ordinance, you should wait for our last item.
Okay.
We're not here to discuss that right now. It's
Okay.
just strictly
Okay.
this
I understand.
vacation home rental, and we're getting way off the subject.
Okay. Thank you.
Thank you. Thank you, Judy. Karen, I'm going to weigh in here too before you
Sure.
go on. What you've gone through, we've had that submitted to us to review.
Right.
And I asked all of them whether they've reviewed their packet.
Okay.
I would like all of you to take that into consideration. We read it. We actually read it and go through and try to understand. I have. questions from time to time. I had some from Larry. I hope it wasn't redundant that I asked whether he understood things. To go back is almost unfair to the audience to kind of go through these things. They are part of the record. They are official parts of the record at this time. And we don't limit the time you have. We never have, and we
Okay.
never will. We hope that you take that into consideration when we're sitting up here. Thank you, Julie.
I do. I do take that into consideration, but, this is my first time, and I really wasn't sure exactly how this would go. I understand that you guys got the packets and read them. That's what you're supposed to
I've
do.
actually got yours in there twice.
Oh,
That's how much we get from it
Okay.
because it was submitted at 2 different times.
sure. Okay, yeah,
Thank you.
correct. So, yeah, I do, and I don't want to get anybody else's way, but I have to say too that, this came on us very suddenly. It was just like one day, nothing. The next day, a sign goes up. And what we understood was we had 10 days to respond and get all our ducks in a row. And it's a lot. I had no idea. It was a huge learning experience. Whereas Mr. Kudel had the luxury of a whole lot of time to get all of his stuff prepared and everything looked at and all the consulting that he had to do. So we really didn't. We've had less than 3 weeks to try and do this. So forgive me if I'm covering a lot, and I'll try and be brief.
Thank
I
you.
will. I've got some letters that my neighbors wrote that weren't able to be here. The first one was from a former renter of Stacy's, and this goes back to some history of
We have one
problems.
from a former renter of his, too.
Sorry.
Have some of these been submitted already?
Yes. Yes.
Then I don't think we need to go through them again based on what Karen was saying, the same thing. Why would you want us to go through them again? We don't even have a signature on it to apply a name or a face. But we did go through and read it. It was submitted to us as part of the official record.
Well,
You
that's
question whether we
fine.
actually do
No.
go through and review these things?
No, I don't. I
Okay.
don't. I guess maybe
I just
the
asked that
rest.
because this is your first time. We do read them.
Okay, yeah, and I do. But maybe the rest of the people here, I don't know. I mean, there are other people that are opposing this as well, and maybe
They have their opportunity to speak.
they do, but do they have all of this information? I don't know.
Mr. Chair,
Yes.
the information is so that we can make a decision. Unfortunately, they don't have a vote in that. I mean, I'm not trying to diminish that. The package is online as well.
Right, okay.
I'm just trying to point out that we don't limit time, and we've reviewed these
And
things when we look at these things. And we do allow you to come up. We actually have some questions for you. I'm sitting here with one or two.
Okay, well,
And those begin to get important too. And there
sure.
could never be an end to this. In other words, the next person may have additional letters that they want to submit for the record and go through that we may or may not have. If we don't have the item, but they should be turned in. And we do get a time to review those
Okay,
before in other words, if this is extended or the department in their reviewing, they will take a look at them. But,
I do have one letter that we got very late,
okay,
but I can give that to you, or would you like
we'll
me to
need
read
a
it?
copy of it. And who's it from?
It is from Wayne Barcher.
Okay,
Do you want me to read it, or do you want me to just give
you
it
can
to
go ahead and read it. I
Okay.
haven't.
And
And
I'll
then
give you
please
that.
turn it in to Jerry when you're
Okay.
done.
I will. This is a letter from Wayne and Susie Barcher. Wayne wrote this. It's to express our strong opposition to the request by SADL Properties LLC, Stacy Kudel, for a conditional use permit, which would allow for a vacation property at 13044 Sunquist Lane. It's 2 houses down from them. We've lived at this address for the past 25 years and truly enjoy the peaceful nature of our small neighborhood. Sunquist Lane is a very short, around 0.2 of a mile road running east and west off Forest Road and is a dead-end street. We live at the west end of Sunquist Lane at the dead end. Once you turn off Forest Road onto Sunquist Lane, you immediately cross a bridge over Rapid Creek, and from that bridge to the end of Sunquist, our home, there are only 7 homes in our small, quiet neighborhood. The request for this conditional use permit at 13044 Sunquist Lane is 2 properties from our location. Our assessed property value has increased 75% over the past 2 years, and as a result, our property taxes are now approaching $9,000 per year. We're willing to pay these taxes in part to continue to live in a quiet, safe, scenic, and historic area of the Black Hills. The commission granted a similar conditional use permit for a vacation rental property 3 years ago to the Hammerquist property at 13049 Sunquist Lane. Since that time, our quiet neighborhood has experienced increased traffic, noise, litter, etc. It has been disruptive to the neighborhood. To approve a second similar request within our small group of 7 homes would add unnecessary and unacceptable turmoil to our lives. This would equate to nearly 30% of the homes on Sunquist being operated as vacation rental property. It would dramatically change the makeup of our neighborhood forever. There's no logical reason for our group of long-term homeowners to suffer for the financial gain of one. Short-term renters that utilize a vacation rental property are not truly vetted like long-term renters are. Basically, anyone willing to pay the price can reserve time at a vacation rental property. As a result, it is a very big mixed bag of renters that temporarily occupy the premises. Many of these groups of people abide by rules and regulations, but many do not. To suggest that a vacation home rental property can be successfully managed from the other side of South Dakota relating to noise, traffic, safety, disruptive behavior, and litter by utilizing a series of cameras is ludicrous at best. This equates to an absolute absence of effective management of these issues. As previously mentioned, approval of this conditional use permit would mean that nearly 30% of our neighborhood would now be vacation rental property. This would have a dramatic impact on the market value and marketability of our property. The assessed value would undoubtedly continue to rise for property tax purposes. However, the market value would definitely be negatively impacted. Again, we and our neighbors suffer for the financial gain of one. Please give serious consideration to our objections to the request for this conditional use permit. Please ask yourself if you would like to see your personal neighborhood turn into one with 30% vacation rentals. If it affected you like it will affect us, how would you vote?
Thank you.
Okay, that's all I've got.
Good.
Any questions?
Thank you. Questions for Shirley? I had a couple.
Okay.
All right. Are you aware that they did list in their application a local contact person, Laura Huber?
Yeah, and I did see that, and I don't, that's some of my questions for Stacy as to what that person does or can do.
And we may know that if there's testimony from Stacy or Laura later.
Okay.
All right. When you spoke about complaints you had along the way, I guess I'm having problems in my mind separating from one that was long-term rental versus now that they're looking at short-term. What are we looking at here? Is this a carryover, or is it concerns that took place from the original long-term rentals?
It does.
That's confusing the issue that's sitting here.
I understand that. I can see your confusion, and we don't have any history with him because he doesn't have that permit yet. But I do have history of living next to him with properties that had severe concerns. He spoke at the last meeting about a renter that he had for 7 months and couldn't evict. And he said that his management property people didn't do a good job. Well, he didn't live next to this guy. We did, and it was a horrible problem. This guy he wouldn't even get a garbage service. So he burned garbage in that detached garage.
Mr. Can I interrupt? I'm going to take you at your word, but I still would like to know. In other words, I realize he hasn't had
He hasn't had a good track record with managing
with the
his
long-term rental? Okay.
managing renters.
And many of the complaints that you're talking about in regards to the neighborhood are in that regard.
Exactly.
Okay,
I
that
mean, that
answers
just
it.
speaks to history, and it speaks to him not recognizing the impact on people in the neighborhood. This guy was there, if we had a sheriff's department coming to our door, trying to find this guy. It was
Okay.
awful. And then the other issue was with the people that he had hired to work on his house. He had repairs or a lot of stuff going on. That went on for months and months with people going back and forth. And they
Traffic.
ended up taking up residence in the detached
Okay.
garage where there was no bathroom, no running water, and they were going outside to use the bathroom.
All right.
That
Yeah.
wasn't in that letter, but
But you answered my
I'm
question,
right
that
next
it is in
door.
regards to the issues that were developed out of
Absolutely.
the long term.
Because that's history, yeah.
And then you also mentioned another VHR. Where is, address-wise on the picture, can we bring the
That's
picture?
13049. That's directly across
And
Sunquist from us.
would you please point that out? So that I can't even read the numbers from this
We're
direction.
right, subject, right there,
Right there?
So we're 13046.
Okay,
Stacy is 13044.
all right.
And Rob is right across from us
That, I
at
understood.
13049.
All right. And then the last one, this, because you're local, we do have a letter, and I don't know how many of the other members, from a DACON Consulting. Did you have that? I don't, is that a neighbor or dead?
Nope. DA Consulting, that's Larry Luxinger.
Oh, all right.
That's his email address.
So, all right, Larry doubled up on me.
Did he? He does that.
But
All
that's
right.
good, but at least Larry knows it's in here too.
He does.
All right,
Any
thank
other
you, Julie. Any
questions?
other questions for Julie? Thank you, I appreciate it.
And thank you for the opportunity to hear my voice. I appreciate it.
Is it Celeste LaChance?
Yes, correct.
Please introduce yourself just for the record and go on from there, Celeste.
Celeste LaChance, and I thank the commissioners and the audience as well for your time. I'm not a public speaker, so I apologize in advance for any misspeaks or possibly faints. Just to introduce myself and go on some of the background of myself and my family, Jim and my son Max. Our property is 13030. So we are adjacent, it's two parcels there to Stacy's property. We purchased our property in 2020. We are new to the area. I was a long-term Airbnb host with multiple properties in the Portland, Oregon area. What I did was a 1031 exchange, if anybody's familiar with that, with one of our Airbnb properties. Now, when we purchased here, we had a long discussion as to what we were going to do with the property that we purchased. It had to be a rental because of the way that we were doing the purchase. We also love the property and the neighborhood, so our intent was to eventually move into the neighborhood. What we decided to do was not ask for a CUP because of what was happening with our current Airbnb properties. One of which is I think in the packet, was that we were getting renters under false pretenses. So very, very easy if you're a computer person, you can, rent it under your mom, your dad, your aunt, your friend, if you've had violations or negative reviews. So that was a very common thing that started happening. Now, I've been doing this since 2010. It was a more recent thing as the industry grew, well, so did nefarious activities. So one of the things that we thought too, moving into this beautiful area, was let's respect the area. We're not here to take advantage or do anything, of the like, but we had to do this financial transaction. But we're like, well, the goal here is to be respectful and not, make tons of money off this property, which we clearly saw as an opportunity. Definitely. It's a beautiful home that we purchased. It's a beautiful neighborhood. The intent was to maintain it and to not disrespect the current citizens of South Dakota. So that was a huge thought process. So what we did was we got a long-term family, which lives at that address, 13030. It's a very nice gentleman and his young son and his mom. They're great tenants. Not only did we vest those tenants ourselves, but we also have, we live an hour away. It's not far. We could have totally managed it ourselves. We come up here at least twice a week for shopping. However, we also hired a local management property to make sure that they were in compliant with anything that the neighborhood needed, that they were in harmony, that allowed, a good quality of life for the existing residents of that neighborhood. So we use a company called Bear Property Management. Nathan Dirksen is the gentleman's name who owns it. They have many people that work there. He's been great. Our tenants have been great. From what we understand in talking to the neighbors, everybody enjoys having them there. There are no issues. However, with the change in these online platforms, it is very, very easy to have multiple people, coming and going under false pretenses, which we did have, in the Oregon area when we were doing the Airbnbs. And I had 4 Airbnbs in the Portland metro area, one of which was on site as well. One thing that I wanted to specifically address, which you should have in your packet, but one of the things that also is a huge area where things can go wrong is that I'm just going to read here. A vacation rental home involves multiple people, not just one or two. It's usually a group of people coming together. Multiple families rent these large homes. They're coming from all different places. And they're like, hey, let's meet up. Woohoo, let's have a party time in this really beautiful area. This creates a group of unregulated people that can act in any manner they so desire during their vacation fun time. The multiple large group rotation in a small residential area provides a wide breadth of opportunity to have their presence very well known. These large groups can be intimidating to those living in the area, as they will be outnumbered if they ask them to shut down activities past quiet hours or deal with any other neighborhood violations. Our existing residents do not want to take on the position of management for a vacation rental. However, with multiple groups coming and going and no one on site, this will be inevitable. Property management and confrontations are not one of the reasons people chose to purchase their homes in this wonderful neighborhood. This adds a great burden and much stress to those residing in this neighborhood. I don't want to be redundant. I think that you've been able to read what I submitted. Julie and Larry have already spoken. I think there's 1 or 2 other speakers. I just wanted to kind of express our background, our history, and what we have done to try and maintain a livable family neighborhood. And these are becoming less and less available. And also, if there are any questions regarding my submission.
Questions for Celeste? One, I can't remember from my reading. Are you living there now, or are you still?
No, we are still renting that home. It's only been one renter since we purchased the home.
Okay.
And he and his family have been absolutely wonderful. And again, we vetted them along with my management company that we have. So it wasn't a willy-nilly decision, and coming from Portland, where this was my livelihood, there was a conversation, well, should we just continue what we've been doing, but the reality was we didn't want to take advantage monetarily and be like, hey, well, let's keep this going. We can probably even make more money than we did in the past on this particular property. We saw that. We saw the potential. However, what we decided to do was break even and just cover our costs, respect the neighborhood, and, with the hopes of eventually moving into this particular neighborhood.
And you folks are the contact person as the long-term renter?
We are, and
Or do
we
you
do.
use a management company?
We put in additional, because our management company is local. They're right here in
Okay.
Rapid City. We're an hour away. We have spoken to Michael many times. We go up and do repairs, but we have that additional buffer of a management company because, again, the last thing that we wanted to do was disrespect our neighborhood, disrespect the existing wonderful quality of life that these people in this neighborhood have. So anyhow,
Thank you. Any other questions for Celeste? Thank you, Celeste.
thank you for your time.
Laura Hughes. Did I get that right? All right. Please introduce yourself just for the record and go on from there, Laura.
My name is Laura Whitnable Hughes, and my family owns the property that's the triangle up there, just above, to the right of 13044 and just above 13046. So we don't have a number because we don't have a house on there. But we are the third party in the shared driveway. This map is incorrect. All of the lot lines have been shifted to the right. So when you look at the 13044, that red boundary should be to the left. You know, you see where the shared driveway is? That's where that should be. And I have that for you, actually, coincidentally.
This is not accurate. We know that
Yeah.
it's not accurate. It's off.
Anyway, so I have that for you.
Thank you.
On page 3. And so I've given you a copy of my thoughts about this. I represent our family with that lot. And my parents have owned that lot since, I think, 2007. Maybe it's 2002. So that lot was split off. We have no access to that lot at all except through the shared gravel driveway. So it's a one-lane gravel driveway that dead ends on our lot. So we're the dead-end lot off of the dead-end street, so to speak. So our concerns are a few, and I tried to look. I don't have a copy of the application, so I'm not quite sure what was submitted. But I looked back at your meeting notes from last month, and I see that when you're approving these things, that people can request conditions. And so I've put some
Can I
conditions.
have you stand over a little closer to the microphone, please?
I can do that.
Thank you.
So what I've put together is some conditions that we would like to request that you consider when you're looking at this conditional use property application. I don't know how you determine how many people can be on that property. We do not have a fence. That's a wide open property with a private, single, person use footbridge to 12645 across the creek. It's not public. It's not meant to be public. It's not meant for people to be coming on and jumping on and trespassing on our property. The only thing on our property right now is a gazebo and tons and tons of trees. We've been trying to improve the lot over the years. But it's, people seem to think that it's public property, which it isn't. And that's our concern with unfamiliar temporary people staying in 13044 and how that can be supervised or responded to when there's people trespassing on our property, aside from me going down there whenever there's a complaint and trying to chase people off. Our other issue with that is on that shared use single lane driveway, we have had, and I know, Charlie, you were talking about long-term renter history and stuff like that, but we have had experiences where the fire access turnaround space, which is on your property at the end of that driveway, has been blocked by prior renters. And we've tried to get that addressed to get their stuff out of that area, and it hasn't been responded to. So that isn't so much of a complaint, it's just a question of, if this happens in the future, if someone is coming and staying and they think, well, we can just park on this dead end part of this driveway, they can't. That's our only way onto our property. Should that occur, I don't know what to do or how we get that out of there. And so I don't know if you guys have thoughts on that. But there's going to be these kind of boundary trespassing kinds of issues that we would like to be able to address locally and immediately if they occur. And I was just wondering if you have some thoughts about how we would do that.
Mr. Chair, if you don't mind, I got a couple. One, do you have any signs that say no trespassing private property?
We do not. It's
Okay. I'm going to encourage that, and the reason why I'm going to encourage that is the nonprofit that I work for owns a piece of land here in Rapid City. It's obviously not open to the public land. Even though it's vacant. People tend to want to park there anytime they think they can. It's not theirs. I guarantee you, you call a tow truck company and they come and tow it once or twice, people get the idea. We put private property signs up. People still come out there. They'll host a garage sale on a piece of property. It took us saying, no, we're going to call the cops every single time. We have to be the police of our own property, unfortunately, when people decide to do something. But the moment we've done that, people stop parking on our parking lot. They stop doing garage sales. It is the responsible party member to do that. His clients will get that. And they'll understand that very quickly if we're going to make an assumption that that's what they're going to do in the future. That's just my 2 cents.
Yeah, thank you. I appreciate that. So, because I'll lose my train of thought here if I don't look at my notes. So the question of the local contact, in case there's a problem, is that what the local contact is for? Up here it says someone named Laura Huber, but I don't know who that is.
Correct.
Is that local?
That's what we
property
have
management?
on our,
I don't know who that is, but it would be helpful to know and be helpful for all of us to have that information if we need it. So one of the other concerns that we have is that's a single use or a single lane gravel driveway, and it's maintained by the three of us in these, these properties that we're talking about. So, we're concerned, or potentially concerned, there would be people bringing RVs, trailers, larger, vehicles, things like that, going up and down our little driveway, and that will incur greater maintenance costs for us. And we don't want our maintenance costs increased disproportionately because someone else is going to have a commercial use property, which just means that we need to have some sort of agreement in writing about who's going to blade that and, replace the gravel, and what are we going to do if there's an impact of increased use on our driveway. So I don't know how we address that issue with you guys, but it needs to be considered somehow in a condition when you're looking at this. And the other thing too is there
can
seems
I
to.
stop you? And it's our understanding from the previous meeting, that Larry does most of the current maintenance on it? Is it?
I would guess so, yeah, because we don't have the house up there, but we might put a house up there. And so at this point, we're not using the driveway as much as Larry is using, of course. So, yeah, I would guess that he's doing most of that right now.
And Mr. Chair.
Yes.
Yeah.
No, I just wondered whether you were aware, because it is a private access agreement between you folks.
Yeah, exactly. It's
Okay.
just between the three of us.
Mr. Chair.
Yes.
And the county doesn't get involved with determining who's going to maintenance that. That's between the easement, the individuals who signed the easement. That's between y'all, who and how y'all are going to maintain that. That's not the county's. We don't get involved in that piece.
And I didn't think that was the question. I was going to bring it up later in that regard too, about the joint access agreement. Thank you.
Okay. I might have a follow-up question for you on that in the future about how we address that, or maybe Megan can tell us how to address, I don't know what we do with that if one person's going to disproportionately use.
If it's an easement, you're going to have to talk to lawyers, because usually it's a private document signed between individuals who have access on that. We've dealt with it a couple times through the county, and the best option that I believe even our state's attorneys would tell you to do is go speak to a lawyer on your own, because it's a private contract between all those who signed it.
Gotcha.
The county is not involved in that contract transaction.
Okay, gotcha. And then there seems to be, or there has been, some misunderstanding about the end of the driveway where we have space, of course, for a fire truck to turn around, or emergency vehicles. And that's just for emergency vehicle use. It's not for people in RVs to come and drive on our property to turn around. So it's not a public use of that turnaround space. That's just in case we have a fire or something like that. Are you suggesting again, probably that this is something to do with signage that we need to put up?
Signage, fencing, I mean, those things do a lot to keep people off your property.
Yeah. So, so we have the emergency vehicle access issue at the end of that driveway that we'd like to have addressed, and really with the fencing as well. We'd really like, Stacy's business to put up the fence. So I don't know if that's a private thing or if that's a conditional issue for zoning commission, but I don't know why we should be paying to put up a fence, just because they want to rent out their property now. Do you know what I mean?
Mr. Chair,
Yes.
so I'm going to speak to one piece of this fencing law. You'd have to look up the fencing laws for South Dakota. I know for ag, it's fenced to keep in. I don't know if it's fenced to keep out in town, in a municipality, if anybody has any information on that. So if you're putting your ag animal somewhere, you're required to put a fence up.
Sure.
There's requirements on how much is your responsibility versus the other landowner's responsibility who shares a fence line. I'm sure if you did some digging into that or asked a lawyer on that one, you could get the right answer so that you could maybe, and I don't know, I just know with ag, I can go out there and I can replace the entire fence.
Yeah.
And then I can say, hey, to my neighbor, well, this is the cost that it cost me for your half of the fence. And then you have that discussion. And so I would assume that there's probably something out there, but I'm not a lawyer and I'm not going to tell you which way to go. I would just do the
Yeah,
research on it.
gotcha. So that research do I ask Megan? How do I find that research?
I think you have to do some of your own research and ask your own lawyer, because if you ask, Megan's going to represent the county.
Oh, gotcha. Okay, okay. And then, of course, again, maybe just a signage issue, but we want to make sure that nobody's parking, no temporary people are parking in our shared one-lane driveway. So really, it's just like an access issue are you thinking?
Now, I don't know about that one. Is that a condition in there? Is that?
Travis, I was going to, since we did accept this, I was going to make sure that at least the ones that aren't addressed in our present conditions, that we note these for the record, and that Laura submitted this.
Because that's a health and safety issue. If they park in the driveway, if they park in the access easement and somebody can't access their land on or off, that could become an issue. But
And our ordinance requires them to park on site, so
right.
That's defined.
Okay.
Can I want to go through a couple of these just for
absolutely.
the record so that we understand.
Yep.
And I went down your list. I used your list. The rest of it's so much conversation. But number one, you're proposing that you would like to see a lower number of only two people as the maximum allowable occupancy. And I'm not trying to take this apart or do anything. I'm just trying to get
No,
it.
I mean, essentially like per bedroom. Like, I don't know.
Per bedroom.
Yeah, I don't know how you guys decide.
Yes, you do have that. Excuse me, I
Like
just
your maximum
didn't
occupancy.
follow down the line far enough.
Okay,
All right.
Yeah.
Then number 8, no Class C or larger recreational vehicles. And I wanted to state that they have to provide parking under our ordinance, and it has to be on site. So that's going to be within their property limits.
Yeah, sure.
And then number 9 on your list is, and I jumped to those because the other ones are addressed in the listing that the applicant is required to meet. And those are something that we review before we vote on it. And it'd be clearly stated and identified to clients there is no access turned around lot 4 or 3. I understood that just from your testimony, so I just want to make sure.
Perfect.
Very good. And then you have number 11, if a conditional use permit application is approved, be responsible for increased maintenance costs of the driveway. And you did that in your testimony.
Yep.
Okay, request the applicant install a fence, and we just got done discussing it. That does get into some state issues, county issues, property issues.
Gotcha.
But at least Commissioner Lassiter did explain that. And there be no parking allowed on the one-lane driveway. And that is part of the application process. The planner does state that all the parking has to be on and it's provided for on site. And
Is it possible to get a copy of the application?
you can, sure,
Okay.
sure can. If you'll
Super.
just leave your name, we'll make sure it gets to you. But those are the issues. The other 2 through 7 are pretty much addressed in the conditions that exist right now that, as you noted, you didn't get to see. So, especially about the fire pit, that sort of thing, we're pretty restrictive on that when they want the right to have a fire pit. So there are a number of items, some permits, as well as knowing what the local fire danger level is, and if that says no fire, then they're the ones that's hanging out on the line if
Yeah,
they're doing it.
exactly. Yeah,
That is a criminal violation.
we have people shooting off fireworks randomly that are, renting and visiting the area in the summertime, and of course, we're concerned about fire risk, so I appreciate you
And
considering
fireworks
that.
are a horse of another color, aren't they,
Yeah, they're,
locally?
yeah.
All right. Any other questions for Laura?
All right.
Thank you, Laura. We'll make sure that
Yep.
this gets to Jerry for the record. And thank you for having it all made out in copies for us already.
Yeah, thank you for your time.
Our next one is Susie Adams Parcher.
Is it still morning? No, not
Well, I know how you feel.
Well, and I apologize to everyone. I know that it's taken a long time, but it's something that we are very serious about in this area that we live in because it is small. It is peaceful. We do have wildlife come through. I've had 2 cats taken by the mountain lions, okay? But in 1999, I found this piece of land with this dilapidated house, kitchens. In the kitchen, the cabinets were falling off the walls. I came to the planning commission because there was one corner of the house was in a right of way. And I had to get that vacated. I came to the planning commission. You guys told me what I had to do, got the signatures. You vacated that right of way. Since then, we gutted that. We built a beautiful home. My husband spent 3 years. We got all the permits because we were losing land from the creek. He built a beautiful rock wall. We have worked continuously over 23 years to make this place wonderful. The neighborhood is wonderful. There's one time, several years ago, there was a guy across the creek. He created so much stress for our family because of his behavior, throwing rocks at my dogs, issues, on and on. When he moved, the peace came back into the neighborhood. This issue of having rental homes, not the rental homes, but the vacation rental homes in our neighborhood has already created stress. We were a stress-free area. This has put stress on us. To have another one is going to create more stress, more conflict. My grandkids, when they come to see me, they walk down the street. After hearing about the shotgun incident, which it was not jammed, I do hunt with a shotgun. I know how they work. He did not have the safety on. This was reckless, very. I'm not sure I want my grandkids walking down the street. And there's people all the way from Forest and Flume that almost every day, even in the winter, walk. One person, a couple, may have a dog with them, may not. They walk all the way down. They come down Sunquist. I'm at the very end to my mailbox, and they turn around and they walk back. And several of these people that I know have already commented about the situation at the one vacation rental home there, that they were uncomfortable walking by. So is this influencing our neighborhood, our serenity, our peace? Yes, very much so. Would any of you want that in your neighborhood? Do you have it in your neighborhood? Would you want it?
go ahead. I apologize. This lady needed to go.
So that's what, we have all the ordinances, we have the legal end, et cetera, et cetera. But what it comes down to, I feel safe in this area because we all do watch out for each other. When you have these transient people in there, the safety goes away. People jumping on bridges, shooting off shotguns, throwing trash, tying dogs up to trees, and letting them bark like crazy. This is not our neighborhood. Please do not take our serenity away from us so someone else can make money. Thank you.
Thank you, Susie. Questions for Susie? Just a second, Susie. Questions for Susie?
I do have one. 13049 is a vacation home rental?
No, 130, yeah, yes, that is a vacation rental.
Okay, see, now
So-
we run into the density thing that.
And then
code.
the 13044 is one asking for the
Right.
conditional use. Larry is stuck right in the middle of them. And if this happens, maybe somebody else, maybe they will decide to do this again. See? And then she said they will.
Excuse me. Can't do that.
Well, just saying.
Just for,
Then it's going to be 3 of the 7 homes. I want to die in this place. We've worked so hard for it. To have transients come in and destroy our peace and our serenity is not right.
the only part that I meant, you can't request from the audience to respond.
Well, I don't know what I'm
That's all
doing.
right. I understand.
Excuse me.
I'm just saying, for order, you
Yeah.
can't do that. Thank
Well,
you.
I read in
Thank
there.
you for cooperating.
Yeah, I read in there, and you guys have it in there, where if this one passes, they will probably do the same thing. It's in if you read it, it's in there. So what's going to happen then? And if none of you have ever been up in that area, it's very unique because the creek does flow all the way around. And I am the last house on the left before you get to Lake Pactola. There's nothing else back there. And it's just, I hike up there. It's a wonderful, I've always dreamed of living someplace like this. And it's going to be very sad to have this taken away from us. So someone can make money.
Mr. Chair, have there been problems at 13049, or is it just 13044 that have been issues?
Both places.
Both places?
Both places. Yes.
Examples from the 13049?
Those are the ones that Julie gave you.
Okay.
Yeah. People jumping on the bridge, the owner not picking good tenants when he was renting it. And so even though he says it's family and friends.
Okay. Thank you. Thank you, Susie.
Thank you.
Appreciate it. I don't have any more speaker request forms on that. I would like to ask whether Stacy or Laura did want to come up and address the commission. Are they? Sure. Please introduce yourself just for the record and go from there.
Mr. Chair, can I get one clarification before it starts?
Sure.
13049 is a current operating VHR, right? That's what I understood?
That's what you want.
And 1344 is not a current operating VHR that he's asking for to start one. Is that correct? It's not currently operational. I just want to make sure.
But just so you follow the testimony, I believe it was also the previous long-term rental, just to fill in it had been a long-term rental.
44 had been a long-term rental.
That's what I
by
understood.
Mr. Stacy.
Yes.
44.
Just to make sure that you understood what.
Right.
Okay. Thank you.
Thank
Please
you.
introduce yourself just for the record.
My name is Stacy Kudel, and I appreciate you guys giving me time to approach the committee today. But my wife and I bought this house in May of 2016. We had no intentions of turning this into a income-producing property such as a VRBO. But I wanted to bring this up because even before we bought the house, I lived in it for 4 months. And the owners at that time were Edith and Richard Adamson, and that's going to be Jermaine in a little while. Um, but so I don't want to repeat everything that I've already said. I'd like to add to just to paragraph 2 that, we just decided that we no longer wanted to rent the property out. We wanted to use it ourselves. After COVID and you needed the social distance, we wanted to come up and use the property ourselves. And so we have been. We've been coming up there about every other weekend. And so like I said, my wife and I try to be in the house every other weekend and vacation and long weekends. We've been up there for Christmas for over 10 days straight. And I appreciate the significance and soundness of the community that's up there. Again, that's why we like living up there. But we have, it's not that, we've made a very significant investment into our home, and I would just wouldn't let anybody into that house. We're gonna manage the property ourselves. It's not gonna be managed by any management company. Our rental experience I wasn't even gonna go into that, but it sounds like it's being brought up. Our experience with having, we had a private realtor in town as the manager of our rental property, and the first renter that moved in paid the first month's rent and the last month's deposit. That was the last check we ever saw for 7 months. And I don't know if the lady is still here from the district attorney's office, but it takes you a long time to get somebody out of the house. You can't just walk in with a U-Haul and say, get out. And so one day, we had an attorney involved, and we took the attorney's advice, and she said, if he's gonna agree to get out of there, then just let him get out of there and don't bother him. So that's what we did. We let him get out of there, and it was less than 2 weeks later, he came, I can't say he did, but somebody broke into our garage, our side garage we have a small door just to get into our triple detached garage. And I didn't know of anything that was missing, but I didn't know of anything that was left. But for some reason, that door was forced open with a crowbar, and I had to replace the whole door frame. Let's see. We don't anticipate renting this property out as a VRBO more than 5 or 6 times during the year. Because like I said, we spend every other weekend there, and we like to enjoy the property too. It's not our intent to have people in there for periods of time like that. But living in southeast South Dakota, working in northwest Iowa, and I've traveled to 44 of the lower 48 states, friends all over, and I'm very proud of the home. I share pictures, and I get emails frequently about, can we rent it? Can we come out there and stay for a week and rent it? And so there's a demand for it, and if I can get the conditional use permit, there are people that I know personally. I mean, like, I don't want to name names, but people that I work with that would like to come out and spend like their Christmas vacation in our property. And I can't do that under the current regulations, because if I had more than 2 people stay for a week, I'd be in violation of the Pennington County Planning and Zoning Board. And so to have anybody stay for 2 or 3 days in the summer, that would be definitely out of the question. And I did walk over to Whit Novels on Saturday night, and I had a nice conversation with Dave and Marty and Laura and Todd. And I offered to put up private property, no trespassing signs, and I'd put them on my side of the tree so it's not detracting from the beauty of their property, just to make sure that there was no confusion about where the property line was at. And I have another line of trees, if you look on the picture, if you move that over just a hair, that whole line of trees right there to the west is the same thing. Those trees all designate the property line, and again, I would put, I don't know if they want them on every tree, I'd put them on every tree if they wanted them, but I'd put them on every other, 3, 4 times that it's private property and to stay within that property. I just anticipate that people are gonna go there and, they're come and stay, and they're gonna go to Mount Rushmore, and they're gonna go to Crazy Horse, just like every other tourist comes to, the Black Hills to do. So I would just like to respectfully, seek your approval for my application for my conditional use permit. There was one item that I think I need to address. It was April 29th through May 1st. And the reason that I brought that up earlier about being a renter from Edith and Richard Adamson is because the people that were here 2 weeks ago were here to intern Edith Adamson next to her husband at Sturgis. And the gentleman that was here, I don't really want to mention his name, but he won't mind. Bob Needles is a very well-respected person in Hartford, South Dakota, where I've lived for over 20 years. And he was the son, to tie these together, he was the son of Edith Adamson. I didn't know that before I bought the property. Well, I did know that before I bought the property, but the reason I found out about it was because their property was for rent. And so it was at that time, then I found out that they were related, and it even made me feel better to be able to rent the property when I knew Bob Needles. Their kids were here with them. He and his brother were here, and there's been people say that they rented. I'm going to read this because I'm not going to get it right if I don't. I know that there was mention that kids were on the bridge. These kids were the grandkids of Edith Adamson. My wife and I bought this house from Edith and Richard Adamson just before renting the house. I learned that Bob Needles was Edith Adamson's son. Bob Needles lives 2 blocks east of me, and my daughter graduated from high school with his daughter, so I've known him for a long time. Bob Needles asked me in January if he could rent the house so he and his brother and their families could walk the yard and reminisce on all their old memories of coming to spend time at Grandma's house while they were here to lay their grandma to rest. I told Bob no, but they could stay there for free. As a small token to Edith Anderson and Richard for being so special to me and my family in the 7 years that we've got to know them. I did not, when I was visiting with the Wit Novels the other night, I specifically asked Dave if he had ever given permission for Edith Adamson's grandkids to walk over to the gazebo, and he said he had, that they could come over and look over the gazebo to see if they could see fish. I mean, it's kind of, he's given me the same permission, and Laura hasn't complained either, except if they have people there, then we don't go over there. So the kids were brought up this way. The kids at that time, they've had to have been here since they were born, and now they're over 20, so yes, they're adults. They did not ask for permission to be on the property again, but they were given it once. So I don't feel like the kids were really trespassing. They really didn't know the difference. And then I specifically asked Bob if you had spoke to Larry, because I know that Larry had came and talked to them for walking down there in the yard, and I asked Bob if he had talked to Larry while he was here, and he said that he tried to, but he said he tried to speak to Larry, but after speaking with the grandkids, Larry left, and he did not feel he had a opportunity to be able to speak to him after that. I mean, they were driving around and enjoying the hills as everybody else, plus laying their grandma to final rest. So anyway, I just asked for your approval. I don't expect this to be 40 or 50 people, but if I don't want to break any laws in Pennington County either. So with that, I'll stop my comments. Answer any questions.
Questions for Stacy? Go ahead.
Comment. What you're talking about, I understand, but you are asking for permission for a vacation home rental. We have one down the road from us in Hill City, and there's been no problem. It's just across the road. If my neighbor decided he wanted to put a vacation home rental in, I would be down where you are, like these people were squawking about it. I have nothing against what you're doing, but one across from the other, and there's only 7 houses, that's a lot of vacation home rentals in one area. Law-wise, I don't know. Moral-wise, in my little compass, I'm not sure that I go for that. And nothing against what you're saying. I understand that. But just the density and the new code that we're working on now, density is one of the big things coming up. And we have not come to an agreement with that either. But one across the road from the other, in my mind, I'm not real comfortable with that. So anyhow, and I appreciate you coming up. That's the only thing I have to say.
Any other questions for Stacy? Okay, the chair's going to take and make a recess for, let's be back here 20 after 11.
I was going to say, my thing is at 11:30.
Okay.
But if you want to still recess.
Well, I hate to stretch out. That's 20 minutes. We can live. 11:30.
We're going to do that before making a
decision. Or do you want to need more time other than 11:30?
Well, I was going to say, we're going to do that before we make a decision on this? Is that your intent?
As long as you're comfortable doing that so that we get you out of here at 11:30.
Yeah.
Okay.
11:30 is good for me.
Then we're going to hold the recess.
Yeah.
Thank you. Thank you, Stacy.
Thank you.
Commission's open to discussion. If you feel more comfortable putting a motion on the floor before you discuss, that's fine with the chair.
Mr. Chair, I'll make a motion to approve staff recommendation of conditional use permit CU 23-11 with the following 15 conditions.
Is there a second to that motion?
Second.
Mr. Chair?
Yes.
I'd like to discuss that for a little bit and kind of give the reasons why. First and foremost, our ordinance allows it with approval. It is a use. I understand the citizens' concerns. I don't believe the court case is applicable in this particular situation because the court case very specifically says that it was a multifamily use, and those covenants very specifically said single-family use. This home is a single-family use, so it does fit the criteria and terminology based on South Dakota codified law and definitions. So I don't think that court case has any bearing on this particular piece, and I would probably venture to say that our state's attorney would also agree with that. So what we have to do is we have to look at what our ordinance says. And our current ordinance says, and I understand my commissioners are concerned about density, but that is not in our ordinance yet. So that's something that if we consider that and it's not in our ordinance yet, then obviously those on the other side of whatever the vote goes could take that legal course and against the county. So we have to put it in context of what our current ordinance says and what's allowed, and basis on that, that is why I will be supporting this particular agenda item.
Mr. Chair,
Go ahead, Karen.
I won't be supporting this. I think no matter how we vote on this, it's going to go to court. And I think that's probably a good thing. I think it would be nice if the Supreme Court would look at it again. You know, what was it, 10 years ago or 5 years ago, the Supreme Court said that vacation home rentals are a residential use and should not affect a neighborhood, and I don't believe that's true, so I cannot support this.
Kevin?
Mr. Chair. So my feeling, I respect the public coming up and talking to us and giving us their thoughts on this. Some of my thoughts are that you've had bad experiences with a long-term renter. They're a lot harder to get removed. You also can't choose your neighbors. So if somebody bought the property there and was a very obnoxious neighbor, I speak from personal experience. I have quite a few of them that are not respectful of our neighborhood, and I can't do anything about it. A short-term renter is only there for a limited amount of time, and they may be disruptive. You've got means to try to address that, but they're also only there for a limited period of time, so you don't have to deal with them like a long-term homeowner that is creating constant disruption for years. So I can support this to some degree, but I would respectfully want it reviewed sooner to make sure that the surrounding community has an opportunity to let this happen for 1 year and then be able to weigh back in. So I would offer a substitute motion to approve, but alter condition number 15 from a review from 1 year to 6 months.
Is there a second to that motion? The motion dies for lack of a second. Discussion's going to continue. I'll weigh in. When you look at this, they certainly have me believing that this, and we've all been by this location, I would hope. And it is a separate community from the other ingress and egress situations. They don't have to sell me on that. These particular, I think they keep referring to 7. That's probably about right. 7 particular properties that involve residential use. One or two, I don't know, aren't presently built on. So that part, they've got me convinced. The common access agreement on the road has concern for me in regards to the vacation home rental. Those folks have to live together. We've got one that's not using it. We have one that takes care of it, or has historically taken care of it, and then we have a new property owner that uses it. And it's certainly going to be involved in the maintenance and upkeep to their benefit. But that does concern me that you've got 3 of them operating on the same that have to get along. I do not believe, unfortunately for you, Mike, that density, I don't think there's any way for the county to address density levels that are going to fit in a situation where you're talking about picking them out of the air and saying, if this one's alongside of that one. What we do is we turn it into a liquor license, and then all of a sudden those places become really high priced in that neighborhood, and the rest of them won't be affected. We do have a lot of testimony in here in regards to the fact that property prices aren't affected. I personally believe that if anything, they kind of go up. Because what happens is people start looking at these vacation home rentals from out of state that want to come here, and they begin to pay more. And they're doing it right now on a regular basis. It's showing up on people's taxes, that their property taxes they're getting. We have many, many areas where this has happened, that their property taxes for the rest of the neighbors went up 20% to 100%, just over the fact that property changed hands. So all I'm getting at is I believe this is a situation where this is a neighborhood, and the neighborhood's the biggest factor in my feeling on this. So, anybody else want to weigh in? We haven't heard from.
I've always held that the vacation home owner is the one that dictates the clients that come in there. I believe that Mr. Kudel is trying to do the right thing by getting a vacation home rental 4 guests that he has. He's not indicating, and we'll find that out over time, that he is putting it out on Airbnb or Booking.com or anything like that. And again, I mentioned I've always been a believer that if we have a bad vacation home rental, that's the person that we need to put sanctions on and say it can't continue on like that. So I will be supporting that we give him this vacation home rental, and again, believe that the nature of what he's doing with it will fit in with the community.
Okay, thank you, Kevin. Any discussion from the audience? And I'd like you to limit your time get to the point when you get up here and tell me which way you're coming from. Larry, please. If you please, you still have to introduce yourself again for the record.
Larry Luxinger, 13046 Sunquist Lane. Stacy states in his application that his property boundary to the north is the Rapid Creek. Stacy's property doesn't go to Rapid Creek. 126, well, there's about a 20-foot section of creek frontage that Stacy does own. 13045, 12645 own both sides of the creek. Their property line is on both the northwest and the southeast of Rapid Creek. I've talked to both of those individuals, Alex and Kathleen. They're a younger couple. They're expecting their first newborn. And I've talked to Cal and Tina at 13045. Since their property is on Stacy's side, they are concerned about adverse possession or prescriptive easement. And so they are concerned that they will have to, one, that their property will be, people who are going to be renting that place are obviously going to go down to the creek.
Mr. Chair, was this presented to us before? Is this any evidence that we have before?
Nope.
Okay. I'm liable to call the question. I think we're adding new testimony versus, it's an adding to change maybe someone's vote in that. That should have been testimony at the beginning.
Before you do, may I ask whether there was anyone else intended to stand up in regards to the discussion going on before the vote? Liking you
Call the
calling the
vote.
question, I'm going to ask Larry to continue.
I call the vote.
All right.
Second.
Well, it was my understanding.
Larry,
It's a procedural move,
Larry,
sir.
My understanding prior to this
Larry.
meeting that we were able to respond to Stacy's statements.
Larry, we're under Robert's Rules of Orders. When he calls the question, we're required to call a vote. No other discussion will follow.
You want to make an informed decision or just a decision?
Understand, but I have to ask you to. No. I'm sorry. Until we handle the question that's been called, there will be no additional discussion. Please read the motion for that the question has been called. Jerry?
Are you talking about the motion to approve?
Yes. Would you?
Yes.
Everyone, did you read it, Jerry? I didn't hear anything hardly. I think I can wing it if.
Just a minute. Sorry, I was working on my minutes. I put it in a different spot. I was moved by Lassiter and seconded by Keen to approve a conditional use permit 23-11 with 16 conditions.
Thank you. Everyone understand the motion? All in favor of the motion signify by saying aye.
Aye.
Opposed?
Aye.
Aye.
Roll call?
Roll call.
Kevin?
Aye.
Travis?
Aye.
Mike?
No.
Kevin B?
No.
Aaron?
No.
Carly?
No.
Mr. Chair,
Yes.
does this move to the Board of Commission, or is it only if it's appealed? Does it move to the Board of Commission?
This is conditional use permit. It's my understanding this will be the end result. It does not automatically move board, correct? Or does this one move forward?
No, Brittany Muller, Planning Director. No, this is the decision. Any appeals would have to be to circuit court under a writ.
Does that answer your question, Travis?
Just want to make sure the public is aware of it as well.
All right. That's the end. We're going to go ahead and recess now till 11:35.
I'd make that motion.
Second.
Moved and seconded to recess till 11:35. All in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. And actually, when I call a recess, you don't need.
I know.
We're going to go ahead and call the meeting back to order.
I don't think we're done with it.
Let's see, we're moving on to item number 18, I believe. Go ahead, Christine.
Good morning. Christine Phillip, Assistant Planner. Agenda item number 18 is for conditional use permit CU 2315 to allow vacation home rental on the subject's property. The applicant, owner, and local contact are James and Linda Wrench. Location is 13778 Neck Yoke Road on 3.37 acres of agricultural district. There's no flood hazard on the property. The zoning ordinance lists 7 criteria that the Planning Commission may consider in the review of the conditional use applications. They are listed on the screen. The staff performed a site visit on May 11th and found smoke detectors in each bedroom and fire extinguishers on each floor. South Dakota lodging license has been applied for. They actually did the inspection on Friday, 5/19 of 23. The address is posted on the residence and on Neck Yoke Road. The property appears to meet the standard performance of Section 319 vacation home rental. Staff has not received any complaints for this purpose. And staff recommends approval for conditional use permit CU 2315 with conditions. Any questions?
All right, questions for Christine? All right, thank you. I have a couple of speaker request forms. James Steen Jr.
And Jim Wrench is here if you have questions for him too.
Okay, and the applicant is here. Is there a James Steen Sr.? Okay. All right, then the applicant can certainly come up if he'd care to in regards to the record on this request.
My name is Jim Wrench. I want to thank you for your time. Was there someone that had complained about anything or was going on or not?
I gotta be honest with you, Jim, there could be, but I don't have, they're not here right now. And
okay.
It may have been, this gets to be a long process. The Planning Commission at present does not have a time limit on speaking. The Board of Commissioners does. We do from time to time on special hearings put a time limit, but our meetings are open to the, as well as even rebuttal, we do ask them to limit their time on rebuttal. But we've never been, other than when it comes repetitious, we've spoken of. And this particular past one was a long one here that we just got done, as you well know.
Yeah.
You've been waiting. So I can't tell you whether these folks were for or against you, but they did fill out a request form and they're not here right now.
Okay, so we're good to go.
Yep.
All right, thank you for your time.
All right. Any questions for Jim while we've got him up here? Thank you. Chair would address the motion.
Mr. Chair, I move to approve agenda item number 18, conditional use permit CU 23-15 per staff's recommendation.
Sorry, second.
It's been moved and seconded to approve per staff's recommendations. Conditional use permit 23-15 with 16 conditions. Discussion. I only had one, Christine. Okay, it says one off-street parking spaces. We all have a tough time deciding how many parking spaces. Can you tell me how we came up with one off?
It's just the amount of people that are going to be in a vacation home rental.
Okay. It's based on the amount, because I tried to circle them all through this to come up with some pattern, and either I'm misreading or we just apply it to something that I'm not picking up.
This vacation home rental is only for two individuals, so there's only one bedroom in this one, so that's hence the one parking.
It's based on the bedroom then. Okay, and that would be then a normal development. In other words, they just have one developed parking space.
Right, and that is what a single-family residence requires.
Correct.
So if there's a garage, we've discussed this before, but if there's a garage, we
Right.
consider those parking areas. I believe this lot is large enough
Yeah.
that it's adequate for the number, for
And
parking.
that's the minimum, which we've discussed in the new ordinance. Thank you. All right, that's the only question I had. Any other questions? Any discussion? Anybody from the audience want to speak on conditional use permit 23-15? Discussion from the commission. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. On to item number 19.
Morning, Commissioners. Jason Fennison, Assistant Planning Director. Agenda item 19 is conditional use permit 22-16 to allow vacation home rental on the subject property. The applicant is Lynn Messer-Smith. Local contact is Rushmore Vacation Rentals, Leanne McDonald. Location of the property is 12995 Old Hill City Road. It is 1.16 acres. Currently zoned suburban residential district. Access is off Old Hill City Road, and there's no special flood hazard area on the property. Zoning ordinance lists 7 criteria the Planning Commission may consider in their review of conditional use permits. They're on the screen. Staff's analysis of the request is that staff did perform a site visit and found that there are adequate smoke detectors in each bedroom, fire extinguishers on each floor, and the performance requirements are properly posted inside of the structure. And with that, staff recommends approval of conditional use permit 23-16 with conditions.
Questions for Jason in lieu of Cody? I have 2 quick ones. One, what's the current zoning for the property? Is it still suburban residential district?
Yes,
Okay.
it is.
My next one is, and I wanted to note this, Leanne is on Zoom. Are you there, Leanne?
Yes, I'm here. Hi.
All right, thank you. Just hang in there. We'll talk to you here in just a minute. I usually try to announce it before we get to Jason, but I miss it. Anything else for Jason? Thank you, Jason. I don't have any speaker requests. Anyone here in the audience that's here to talk on this? Okay, Leanne, please introduce yourself for the record and go from there.
Hi, I'm Leanne McDonald with Rushmore Vacation Rentals, and we're just applying for this conditional use permit for this beautiful property. I work for Lynn Messer-Smith, who's the owner. And did you guys have any questions for me?
Any questions for Leanne? She is the local contact. Is Lynn on the Zoom as well? Just you, Leanne.
Yes, I think I can make.
I think
Oh,
I got
just had it turned off.
missing.
Here we go.
I had some misinformation.
Hi.
I had Lynn as the one that was on the Zoom. Okay, we see you now. Go ahead. Any questions for Leanne while we've got her on here? And it's Rushmore Vacation Rentals, is that correct, Leanne?
Yes, that's right.
No questions for Leanne? Chair will address a motion then.
Mr. Chair, I move approval of CU 23-16.
Second.
Moved and seconded to approve conditional use permit CU 2316 with 16 conditions. Discussion from the audience, from the commission. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. On to item number 20.
Agenda item number 20 is conditional use permit 23-17 to allow a bed and breakfast on the subject property. The applicant is David Allard. Location of the property is 12530 West Highway 44. It is 3.86 acres. Currently zoned suburban residential district. Access is off Highway 44 west. There is special flood hazard area on the property to include 100-year and floodway. Again, the zoning ordinance lists 7 factors the planning commission may consider in the review of conditional use permit applications. It's a little small, but it is up on the screen, and it's also in your packets. One correction that I wanted to make to my staff report that you guys have is under the on-site wastewater treatment system. I did list an operating permit. It was my mistake. That was a first notice that was sent out to him in 2019. So staff would like to add a condition of approval that the applicant obtain an operating permit prior to the operation of the bed and breakfast if this is approved. Staff's analysis of the request is that the applicant is requesting to construct a detached 1-bedroom residence to be used as a bed and breakfast. On May 15th of this year, staff did perform a site visit and verified a single-family residence has been converted to 2 bedrooms. It was a 3-bedroom. He deleted one of the bedrooms to allow the capacity for this one detached structure to be used as a bed and breakfast. He also did get a letter from the state approving his on-site wastewater treatment system for the uses that are currently on it. If you look here, here's the applicant's site plan. I'm not sure how familiar you guys are in the Johnson siding area, but if you look up on the cliff side, you can see that platform. That's what we're talking about here today. This is a picture of it from Johnson siding looking up. In relation to the property, he does have his single-family residence here, the detached garage, and then the platform up higher on the hill. With that, staff recommends approval of conditional use permit 23-17 with conditions. I'd just also like to note that staff has received multiple letters of objections to this, and I believe you've all been provided copies of those letters. And again, staff recommends approval.
Thank you, Jason. Questions for Jason?
A couple questions.
Go ahead,
Jason.
Mike.
Put the plat back up there, if you will. Yeah. So the one on the far right and the one on the far left are going to share a septic system?
Yes.
That seems like quite a ways apart.
Mm-hmm.
You know,
it's all downhill, so I mean, it all runs downhill.
I guess it does work that way.
No pun intended.
No. I have never seen a bed and breakfast detached.
No, we've had quite a few of them here in the county.
Are there? Okay, all right. It just seemed a little strange that this wasn't within the house itself. So I guess that was my main thing is an actual separate detached bed and breakfast. But if that's kosher, that's the way it is.
Right. And then I do have a rendering of what the applicant is proposing for that platform.
Mike, to answer your questions, I believe there is a number of them. Old rule of thumb, and there was some director involvement in this too, of their own discretion to meet the laws. But basically, it used to be considered contingent. In other words, it was on the same piece of owned property. It may not be exactly platted on the same piece of property, but it had to be contingent to the applicant's housing. And there are a number of them that don't stay necessarily exactly on their property on top of them. So I'm aware of other ones, and this didn't come up as an unusual request.
No.
Any other questions for Jason?
I have a question about the platform that this will be built on. Is that the platform that exists now?
Correct.
And is it anchored? Is it?
It is, yeah, it's substantially anchored. I did have pictures of it. I didn't include them in my presentation though, but it is anchored in concrete pillars up on that cliffside. And the applicant is here if you want to have him come up and speak to exactly how he's got that anchored.
Other questions for Jason? I was going to point out that our black and white pictures weren't as good as our color ones in the past, so I understand what you're saying. The anchoring probably would have shown up a little better. The right button didn't get pushed or something for color this time. Thank you. We're all spoiled, one or the other. Any other questions for Jason? I do have a number of speaker requests on this. Thank you. I'm going to try to go through the names and make sure I get them right. First one is Eric Newman.
Eric at the lead.
Okay. How about Carl Schwarzenberg?
Yeah, you said it right.
Thank you.
My name's Carl Swazenberg. I have one of the properties that butt up against the lighthouse project here. And I just have a few questions because I was told the way the utilities from this building, the B&B part that was going to run, he was going to umbilical cord the whole mess into the house. And when I talked to planning, they said he can't do that. But now I guess he can do that?
So I'm not sure what you mean by umbilical cord. Are you talking tying the septic systems together?
Septic, electric, water, the whole 9 yards, and
Right.
and like umbilical corded to the main house.
Yes.
And I was told by you guys that he couldn't do that. But I guess he can now, right?
Yeah, he can tie his
Okay, all right,
cables
all
together,
right.
yeah.
So this property that he's doing this on is part of Pine Cliff Estates. We have covenants, and our covenants say no two residential buildings on one lot. So I guess this, correct me if I'm wrong here, this B&B permit would dissolve the enforcement of our covenants, and he could do whatever he wants then? Am I correct?
Mr. Chair.
Go ahead, Travis. I know you've had to, and we do too.
Right. Covenants are not something the county looks at. Covenants is a private contract between those and all that. So whenever it comes to covenants, we may look at them and consider them, but it does not mean we have to act on them. We have to act on our ordinance, not necessarily on the covenants.
Okay, so if you approve this, then you're going to be setting precedents for other 70 houses to do the exact same thing. That if he gets this approved, then I'm going to put cabins up, down on the bottom of my property and apply for the same thing then.
Who enforces your covenants?
We do.
Then you have to, if you want your covenants enforced, and that's what I've been up here, what I've seen a lot of times, people come in here and complain, and they get the covenants, and I see it all over the place. Covenants are violated, but people complain about them. But if they're not enforcing them, those who have the rights to enforce them, then that's why they keep getting violated. So what I would say is if there's covenants, y'all have to enforce the covenants because the county cannot enforce your covenants.
We've been trying to enforce the covenants. And this is where we're at. This is the loophole, I guess, for him to legally violate the law. So anyway, back to access. There's no access to this platform other than if you hike up the hill. Is there anything that he has to do to provide access as renting this to an Airbnb?
I don't know the details of the property, so I'd rather staff who's been out there and who has all that.
So the requirement is that he provides a parking spot for the bed and breakfast, and he does have adequate parking. Whether he wants to provide a hiking trail to get to the actual structure, I know the applicant does plan on putting a road in there to get up to it, and that's just during my conversation with him during the site visit. But those details, again, we could have the applicant come up when it's his turn to speak, and he can probably talk to that a little bit more.
Okay.
One quick one for Jason, and the parking must be on site.
Correct, yeah. He's got adequate parking down below by his main residence.
Just wanted to clarify that. Okay.
All right. And then the last thing I have is, ever since this platform's been built, my life has been hell. I've had people walking through my yard, parking in my yard, knocking on my doors to go look at this platform. And I keep referring them down below and everything like this. It's gone on all last summer. And I'm just tired of it. And so I guess that's about all I have. Oh, one other thing on access. He does not have the right to make me give him access for that landlocked site, correct?
You mean like through an easement?
Yes.
I don't believe he can make you do that. He can offer you. He can
Right,
offer
okay.
to buy land.
Okay.
He can offer.
Okay, that's all I have. Okay, thank you. Anything?
Any questions? Thank you, Carol.
Thank you.
Sally?
Yeah, I believe.
And is there a Vicky or Vic? Vicky. Please introduce yourself for the record and go on from there.
Hi, I'm Vicki Franzen. I am on the Pine Cliff Water and Maintenance Board. I'm the vice president. And, you know, I think you've got a number of objections via email. One of the things that, again, I think one of those people in that longer presentation earlier mentioned that we just got this letter. Those of us within 500 feet of this property just got a letter like 10 days ago. And although our board has vocally said we, don't want a second resident built on a lot, and again, I appreciate covenants, and we will probably step forward to enforce that. But the other thing that in your, well, okay, let me just keep on this train of thought. We didn't have really time to do anything at this point. 10 days doesn't, to try to get a group of people together. So, if you were ready to vote on it today, I would ask that we continue it to give us a little more time to kind of get our ducks in a row and get the legal representation that we need. But that's just a request. Going to those 7 conditions that come up, one of them says, are adequate utilities, et cetera? And it says yes. Well, we provide the water. And one of our concerns is with additional properties being built, that is going to start to, maybe this one won't do it, but if this continues on as a precedence, it's going to start to tax our water system. And that is what our board is tasked to do, is to manage the water. Again, and maybe this is just a thing where we just have to go through our legal avenues, and you really don't have much to say on it, but it's a huge concern. I think that's one of the utilities that was not addressed here. Other than that, our board and our residents have sat through the commissioner meetings in the past on vacation home rentals and opposed them because of just what those previous people talked about. It just turns your neighborhood into something other than a neighborhood. I know you guys aren't familiar with this, but the house below is accessed from Highway 44, not our roads. But up above, when you get up into this proposed B&B, then it's just a straight walk. And that's what people are going to start doing, and that is through Carl's property. They're going to start walking up because that's what you would do. We'll probably do the signage, I get all that, but I think as by and far, it's, we do have vacation home rentals. We do have problems with them. We do have people speeding. We do have trespassing. And then just to turn this into actually building a second resident, and I think as Carl said, it just gets to that point of, are you opening a huge can of worms? Because we would turn our residents into 70 homes that we're supplying to potentially having now 140. And we can't do that. We couldn't supply the water. Now, again, that's forward looking. I don't know if you guys even consider that when you make your rulings on these, but those are some of our concerns. And thank you.
Thank you.
Mr. Chair.
Yes, go ahead.
Fully aware of those concerns, and we do hear those. Some of those we just cannot take in consideration because they're not within our purview. If you have a water district, road district, those are quasi-governmental entities that are designed so that you can set the rules and guidance of those who are part of that system. So I would always encourage, and I've done this many a times, and Megan's heard me say this many a times, if you have a road district, if you have a water district, if you have any of that, y'all need to review what you have out there as far as what's acceptable, what's not acceptable, and y'all need to make sure that it's put in their covenants, and then y'all have to address them, but y'all also have to be the ones that act on them when someone violates them as well.
Well, and that's what we're attempting to do here, because our covenants say, and our water regulations say, we're going to supply a home. Now, here's a second home, and if you make it legal, can we say, no, we're not going to supply water? Those are things I don't know.
Sorry, I'd like to interrupt. Megan Kruger with the State's Attorney's Office. So I've heard twice now, make it legal. There are many different avenues for something to be legal. Just because under our ordinances something is legal doesn't mean that it's legal under your covenants. So you guys need to hire your own attorney, and you need to talk to an attorney about your private issues or the issues with the water district or road district.
Thank you. And that was I guess, where I had asked initially if we could postpone this approval to give us time to just do that legal review.
Any other questions for Vicki? Go
Mr.
ahead,
Chair,
Trev.
I'll just caveat to that question there. If we're going to follow our ordinance and if we pass it or didn't pass it, what would that do for you? Because if you're going to have to go down a legal avenue, we may not have to look at that because of our ordinance versus if you have your water district, for example, and your lawyer says one thing or another, that's not going to impact us, I don't think. We're going to vote for it based on our ordinance and the way it stands. Does that make sense?
It does, and the only reason I would ask is because, and again, I don't know how fast Dave's going to get started on this, but if you approved it, and then he got started, then we went through whatever we're going to go through, and we're successful, and we say, no, okay, legally he can't do it. Is he going to put a lot of money into something that he's going to be squashed and not be able to complete?
Okay.
I have a
Thank you,
feeling
Vicky.
Jason wants to chime in on that.
If I might. So there is a 30-day appeal period from the time that, if this is approved today, there's a 30-day appeal period. So I can't issue him a building permit until that 30 days is up.
Okay,
So there is that 30 days.
all right, thank you.
Thank you. Anything else for Vicky? Thank you, appreciate it.
I have a question.
Sure.
Why, we're being asked to allow 2 residences on one suburban residential lot. How is that okay?
I'll let Jason go ahead.
So the use is the bed and breakfast. It's not another residence. It's the bed and breakfast. It's a detached structure for that use.
Will this bed and breakfast have a kitchen in it?
So I'll let the applicant come up and speak to that.
Says yes, so.
Okay. Thank you. And before we get to that, I want to make sure that for the record that Jason, and I think you were involved in getting these, we did get some copies of, let's see, Stephen Gifford, we got an email or memo. Fingers aren't getting apart here very well. We got one from Amy Wagner, and we got one from Aaron Schneider. And then Patrick Anderson, just for the record. And that was given to all of us? You all got your copy? Okay, very good. Let's go on to the applicant. Dave, please introduce yourself for the record and just go on from there.
Name's David Allard. I'm the owner of this property. First of all, you got to understand with Pine Cliff Development, I'm the only property that has its own driveway off of Highway 44. I have nothing to do with the road system in Pine Cliff. I'm totally separate. And I adjoin a commercial property, which is the mobile home park, which I also own. This is just a little tower that I want to build. It's actually got a little bit of a historical look to it because it's actually just about 20% larger than Custer Peak Tower, if you're familiar with that. And it's got the same lines. And basically, I just wanted to put just a little bed and breakfast unit there. So I can have a bathroom and a bed. And it's just, I'm not affecting anybody in Pine Cliff. I got Highway 44 straight up, and then I'm cutting in a road, still waiting for my big track hoe to come up and cut me a road. It's about 50 feet higher than my house. And my house is about 50 feet higher than the creek. So it's just got about a 100-foot overlook, and it's all by itself, and it's basically designed just for 2 people, 1 to 2 people. It's going to be a higher end bed and breakfast. And I don't see how I'm going to affect anybody on Pine Cliff.
When I asked the question, Charlie, it's okay, can I
Go
speak?
ahead.
When I asked the question about a kitchen, you said there would be a kitchen in it?
I showed them my print, and it does show a small kitchen in there. So like a kitchen, living, dining down below. It's got a little spiral staircase in the upper. It's just 21 by 21 on the first floor with the deck is 33 by 33, which gives me a 6-foot wraparound deck. And I built that about 4 years ago, and I was never able to finish it due to financial constraints and a divorce and stuff. And now I'm at a point where I've moved into that house, and it's my permanent residence now, and I'm just trying to finish that platform and build a little structure on it. And I approached planning and zoning, and I tried to explain that this is what I want to do, and they said going the bed and breakfast route would be the way to go.
So what, is it a kitchenette? There's no oven, right? There's no range, no oven? It's just a
It just,
refrigerator?
I just really haven't designed it yet. I mean, it's
Right.
just,
So if it were a kitchenette, I believe that we could move this forward. If he wants to go forward with the kitchen, the full kitchen, I believe that we should probably continue this so we can discuss it more.
Okay. Jason, don't go away. And don't go away, Dave. I had one too. And I don't know what the rest of the commission's familiarity with. When you see a piece of property and it's platted or laid out with specific guidance on it for us to be able to look at, no matter how long ago it was, whether it's today's rules or yesterday's rules, doesn't really matter. But there had to be, I'm sure, an access on there somewhere. And the county does recognize legal access on that. And I guess I had a question on that. In other words, we talked about, or some of the testimony was in regards to where's the access going to come from? Well, that document says where it's going to come from, and it was all agreed upon way back whenever it was filed, which I don't know, and I'm not sure you could name off the top of your head. So I have a problem with not continuing it as well. I'd like to know about that access before we look at this. I don't know what the feeling is on the other commissioners, so if you'd like to weigh in, go right ahead.
Mr. Chair, I think Jason made it clear that we need to know what kind of kitchen, because if it's going to be a full kitchen, then that does require some more research if it's going to be a kitchenette. But it has to be written in the conditions that it's a kitchenette. It's only allowed to be a kitchenette, so we'd have to modify the current conditions that we have as well if we were going to move it forward. Or the best thing is probably to continue it so he can put his plan, so we see the active plan before us to know that that's what he's going to do and there's not going to be a change.
I guess I would concur that Mr. Allard should have the right to review these options and see whether he wants to, which direction or avenue he'd like to go. But again, the chair's going to have to hear a motion to continue it so that that's going to happen. And I'd like our access looked at as well from a historical document. I think you guys can walk across the street from your office there, so to speak, and get that. It's on a document somewhere. It says where, I think the state of South Dakota requires it, that it has to have access somewhere on that document.
There's legal access to the property from Highway 44 West.
No, I'm talking about the piece of property up above.
This is
You
all
can't
one.
landlock somebody's piece of property. If he's got a separate piece of property up there that doesn't go into the road district.
It's not separate.
It's all one piece of
It's all one
property.
piece.
it's almost 4 acres.
Agreed, but I'm saying somebody that surveyed that knew that you couldn't drive from this driveway up the block wall to get to it. You can't landlock somebody's piece of property and plat around it. So somewhere along the line, somebody had to give access to that.
Can't, the line's so far off.
So
No, the one up above the creek. The part of it that's up above the creek.
this part?
Yeah.
Yeah, so
Somewhere
this
there's
is all
got to
one
be
piece of,
access to it.
so it's one piece of property. There's one access to this piece of property from Highway 44.
That's what's required.
Okay.
We're dealing with a piece down in Hill City, I believe, that they want to replat it, but they can't replat it because of the potential. This one, he's not asking for replat, so it still counts as access to the whole property.
Show me again. All right, his access comes in way down there. I thought it came in back to the right.
No.
He's got access right there.
So
That
this
can
is,
go to the top of that ridge.
there's currently no road that leads up to here. No
Okay.
driveway or anything that connects
At this
driveway.
time. In other words, that's an access that he would have to continue. The access comes off the road at that piece of property right there, and he would have to carry it up to the other.
If he chooses to.
Okay.
Yeah.
Then I'll stand corrected. Thank you.
Mr. Chair, I'd move to continue this item to the next Planning Commission meeting
It's June 12th.
of June 12th.
Second.
Moved and seconded to continue Item number CU 23-17 to the next Planning Commission meeting, which is the date they include?
June 12th.
June 12th.
June 12th. Discussion.
Mr. Chair?
Yes.
We need to see a floor plan. You know, that I was going to ask that before, because that'll dictate a lot of what is going in there. If there's a full kitchen, that changes everything. If it's just a kitchenette, then that,
Okay.
then it's just an additional structure.
All right.
Mr.
Jason?
Chair, I'd also recommend that you put in that other item that we talked about for the on-site wastewater treatment system.
Yes, sir.
That way it's already in there.
I was going to, that's true. Need to add a condition. I had that one written. I need a secretary over here today to keep track of all the little side pieces of paper I'm getting. No, I agree. We do need to add a condition for the one you proposed at the onset of this item. And I'm sure you'll take care of that by the next meeting as well. Any other discussion from the audience, from the commission? Yes?
Yeah, if they had I agree with the kitchen deal, because if it has a kitchen in it, then it becomes multifamily. And definitely dual residences, as we've voted on numerous times with other single-family homes with separated kitchens. So, yeah, we definitely need to understand what that final building's going to look like.
I concur, and I'm sure Jason and the applicant want to review that at this point in time so that it's all taken care of, cleaned up. All right, any other discussion from the commission? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. We're on to item number 21.
Agenda item number 21 is minor plat 23-09 to subdivide and create lots 1 and 2 of Bentliff subdivision. The applicants are Glenn and Michelle Bentliff. Surveyor is KTM Design Solutions. Janelle's in the audience if you have any questions for her. Location of the property is 12781 Old Hill City Road. It is currently 15.2 acres, and I did have a typo in the staff report too. It is zoned Ranchette District. Existing land use is residential, and there is 100-year special flood hazard area on the property. These are the previous conditions of approval from the layout plan. Current zoning is ranchette, not agriculture. And this is a rendering of the proposed lots. You can see lot 1 in green and lot 2 in red. Lot 1 will be 6.15 acres. Lot 2 will be 8.46 acres. Staff has not received any letters of opposition for this. The analysis of the request is that the applicants are proposing to subdivide and create 2 lots and dedicate the remaining portions of the balance as public rights-of-way. October 19th of last year, the Board of Commissioners approved rezone RZ 22-26 to rezone the subject property from agriculture to ranchette district. Again, there's another typo in my staff report there. It should say ranchette. With that, staff recommends approval of minor plat 23-09 with conditions.
Thank you. Questions for Jason?
I have one. This is just up the road from us. I'm familiar with it. The Black Hill Central 1880 train runs through this property. Is Lot 1 on the other side of the railroad also?
It is.
Because there's no public access, no access for them to get from one side to the other there.
Yeah, and there's a note on the plat that states that future landowners will have to work with the 1880 train to secure access.
Yeah, well, I know how. Yes, right. That would be very hard to come by at this point. That's why I was just curious. It's because it's going to kind of be landlocked as far as from lot 1. But no, I mean, I can't see any problem with it. I was just curious.
Mm-hmm.
Any other questions for Jason? Okay. Anyone from the audience here to speak on this item? Minor plat. KTM Design, are they here? I think they left too.
Yeah, Janelle was here.
I thought I'd seen somebody here. Okay. Chair will address a motion.
Mr. Chair, I make a motion that we accept item agenda number 2309.
Second.
All right, moved and seconded to accept staff's recommendation on MPL 23-09 with the 4 conditions that are still relevant. Is that not correct, Jason? Thank you.
That's correct.
Okay, discussion. Anyone from the audience? From the commission? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. On to item number 22.
Agenda item number 22 is lot line adjustment plat 23-11 to combine 2 lots and create lot 3R of tract 11 of National Placer MS 688. The applicant is Paul Von Fisher. Property is located near the intersection of Burlington Road and George Frink Road. It will become 0.545 acres. Both properties are currently zoned suburban residential and they're both vacant. Access is off George Frink Road and there is special flood hazard area on the property. This is the criteria from the layout plan that staff considered based on their recommendation. Again, both properties are zoned suburban residential. Currently, the smaller of the 2 lots is 0.15 acres and vacant. The larger of the 2 lots is 0.38 acres. Combined, they'll be 0.53 acres. Register of Deeds did have 1 comment, and that will be addressed as a condition of approval. Staff's analysis of the request is that the applicant is proposing to remove a lot line and combine 2 lots into 1 parcel, as you can see here on the screen. There are some issues with the certificates that will have to be addressed, and those are made conditions of approval on the staff report. And with that, staff recommends approval of lot line adjustment 23-11 with conditions.
Thank you, Jason. Questions for Jason? Any questions from the audience? Chair would address a motion.
Mr. Chair, go ahead.
I move we approve LAPL 23-11.
Second.
Been moved and seconded to approve LAPL 23-11 with 8 conditions per staff's recommendation. Discussion from the audience. From the commission. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. We're on to number 23.
Agenda item number 23 is rezone 23-06 to rezone 7.2 acres from agriculture district to rural residential district. The applicant is Free Range Rentals LLC. Their agent is Davis Engineering, and I believe Ron Davis is in the audience if you have questions for him. Location of the property is 23707 Burnt Fork Road. Again, the lot size is 7.2 acres. Currently zoned agriculture district. Access is off Burnt Fork Road, and there's no special flood hazard area on the property. Planning Commission has seen this request before. The previous request was to allow it to be rural residential, I believe, or ranchette. The applicants are proposing to subdivide the property into 2 lots. Layout plan 23-04 was approved by staff on March 2nd of this year. On October 18th of last year, the Board of Commissioners denied a comprehensive plan amendment to end rezone to change the future land use from to low-density residential district. May 2nd of this year, the Board of Commissioners approved comprehensive plan amendment 23-03 to change the future land use from ranchette to rural residential. With that, staff finds no significant issues with the request as it appears to be in harmony with existing land uses in the area and is supported by existing roads and infrastructure. The majority of the properties within 1/2 mile are zoned residential lots. With that, staff recommends approval of rezone 23-06.
Thank you, Jason. Questions for Jason? Okay, and the applicant's representative agent is here, but do we have any questions for Mr. Davis? He certainly would come forward.
This is just a rezone.
Mm-hmm.
Yep.
All right. Anyone else from the audience here to speak on the rezone on 23-06, free-range rentals?
Mr.
Chair-
Chair, move
Chair,
to approve RZ 23-06.
All right. Moved and seconded to approve per staff's recommendation, RZ 23-06. Discussion. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. Okay, we're on to item number 24, I believe.
Mr. Chair,
Yes.
I move to discuss items 24 and 25 as one in lieu of our normal rules as they pertain to the same property.
Is there a second to that just for discussion?
I second.
Okay, on this one, I'm not sure we can do that because
They're not
the
exactly the
properties
same.
aren't identical.
They're not exactly the same.
Right. It really would be inappropriate to do that, even though it involves many of the same factors, but the property itself is not identical. So I would hope that I could talk in and take in your motion.
I will rescind my motion.
Thank you. And your second is?
Also.
All right, Brittany. Now, one other thing I want to throw in here, a lot of folks submitted, or some folks submitted speaker request forms. I'm not separating between 24 and 25, so I may call your name twice is what I'm getting at. When 25 comes up, we'll go through it again. All right, thank you.
All right. Item number 24 is Comprehensive Plan Amendment, CA 23-05, to amend the comprehensive plan to change a future land use from suburban residential district to urban residential district. And just a little history on this property. It is only the 6.52 acre portion of the property that they're looking at. It's currently being platted within the city of Rapid City right now. And then just, like I said, a little bit of history on this. This property was rezoned to urban residential back in, let me see the exact date, I believe it was in 2021. This planning commission did deny that rezone, but the Board of Commissioners did approve it. The reason that the comprehensive plan amendment wasn't submitted at that time is because it was during that time when our comprehensive plan, our big comprehensive plan was being adopted. There were some issues with the future land use maps and the current land use maps that we worked through with the state's attorney's office and had to approve some maps in our comprehensive plan. So they did not submit a comprehensive plan amendment during that time for this one. And they wanted to wait to see if the rezone was going to go through. The planning commission did deny the rezone. The Board of Commissioners did approve it back in October of 2021. Since that time, just to kind of give you an idea of the area around there, the property, the area in question here is right in this location. There are some different land uses that are around here. The Apple Valley subdivision is approximately right here, which is zoned urban residential as well. And just a general understanding of the urban residential district, because I know that this commission does not see that district very often. The uses by right are similar to those that are allowed in suburban residential. The biggest difference with urban residential versus suburban residential is it does allow multifamily residences in that district as a use by right. And a multifamily residence is defined in our ordinance as a fourplex or lower. So if you go up to 5 families or more in one structure, it moves into a conditional use permit. So if they go to an apartment complex or an apartment, it would have to come in front of this board again as a conditional use permit. So I just wanted to make that clear to this board before.
Mr. Chair,
Yes, go ahead.
Brittany, how many in this particular area, how many of those fourplexes could fit?
They can have one on this lot without going through the conditional use permit process. So one structure.
One structure?
One fourplex.
One fourplex. Okay.
Correct.
Any other questions for Brittany? All right. I've got a number of speaker request forms in this, but I do have a question before we get to that. I've got and I'm scratching my head because I thought KTM was the engineer in this. I've got a Ron Davis letter on this. This is Murphy Ranch Estate subdivision?
I can tell you why you got that.
Please come up,
Well, I'm speaking thing too.
and you've got to, you got to introduce yourself just for
I'd
the
like
record.
to copy that letter also.
Okay.
My name is Howard Rice. I own property, 40 acres abutting to Murphy Ranch. In the letter you have from 2002 from Davis Engineering, where he told there was nothing there other than alfalfa fields, that he was going to put up single-family dwellings in the neighborhood of 140,000, which is to 180, something like that, which is kind of ridiculous now. But also there'd be a ball field and a soccer field for everybody in the valley to use. I think you all have that letter in there. And the houses were being built, and they've been being built up to now.
Okay, Howard, can I interrupt you then? I understand what you're talking about. Is this going to be part of your testimony that this is historical?
Yes.
Okay, then I understand why I just wanted to let you know, and I wanted the staff to understand that this is part of our records for today.
Right, and just for clarification, I kind of understand, Mr. Davis was the original owner of this property before Pink Cabin LLC purchased it.
Okay.
So because it was originally getting developed. Mr. Davis was originally the developer in some of the initial phases of this project in Murphy Ranch, because it's a significant property, and now Pink Cabin LLC is developing.
Just for you and for Howard, I just wanted to make sure so the commission takes this under advisement in the proper context that it should be.
And Mr. Chair, and to clarify, this piece of the property, is that what this letter is referencing, that this is essentially the
That's
area
why
that
I
was
asked
set
Howard
aside
about
for the soccer field?
Yes. This whole 80 acres, or 84 acres, whatever it was back there, that's how this whole area was going to be developed before, I guess, fortunately, was sold off to Pink Cabin LLC, I assume.
Go ahead.
And if I may, Chair, in the original plat documents from Mr. Davis, this was actually single-family residences or lots. They reconfigured some of these lots in the streets, and that's why we are here.
I just want to make sure that we hold this, so we don't go through this twice and be dumping away on it, that we hold it for Howard's. You're listed as one of the speaker requests. In fact, you're the very first one anyway, Howard, so you might as well go on.
I'm going to continue on with, I believe, last, October 5th, in front of the planning, the county commissioners. Andy Skoll was questioned again about the piece of property which is also part of Murphy's Estates, which is south of the irrigation ditch and north of Highway 44, where they asked the question of the development that he was doing, and he said, I'm making this development just like the rest of the development north of the irrigation ditch, single-family homes. Well, if we're going to go now and go from suburban to urban, I don't think that fits. That's not how everybody in this entire neighborhood around there was told, either one way or the other. And as far as I'm concerned, we're in a single-family neighborhood. And if you're going to go do this, then you're changing the whole complexion of what was promised to the original people that bought houses in this area.
Howard, can I interrupt you? Because we actually have one speaker that's got to go. And I'll bring you right back up. Would you give away to a lady that...
It doesn't make sense to me.
I just read her note. We're going to bring you back up and let you finish, but I would like to get her before she has to go. She did give me a letter. Thank you, Howard. I want to go with Linda Carter and...
He can continue. I've already gone and come back.
Oh, have you? I saw that. I saw that. Okay. a gentleman, and then the lady just curtsied to you and let you go back. Go ahead, Howard. Thank you. Thank you, Linda.
I just don't think it's fair. The people, everybody that's bought a house out there, it was bought under the contingency it's going to be single-family dwellings, especially when you start out with the whole 84 acres. This is what this is going to be. I don't understand why we don't keep up with that. I think that's a responsibility of the Planning Commission and the Board of Commissioners. Now, if it's an entirely new set and we're starting someplace from a flat piece of ground that nothing's on, entirely different deal. But I think we're doing a disservice to the residents that are there now who have bought houses. And the only reason you want to go to put some more houses in there and make some more money. And I don't think that's the proper way to go about doing it. I think you should stick with what was originally set up and go from there on it. That's all I've got. Anybody have any questions?
Woman, go ahead. Question is for Howard. I do. You seem to know the history a little bit, Howard. When, in fact, in this letter from 2002, was that in relation to other property that was sold or just this property that comes up?
Just Murphy's. And they owned all of that and also south of the irrigation ditch, which Pink Cabin LLC bought. It goes down to 44. And you can see that on the on Brittany's bigger map where you got that on there.
Do you know what prompted this letter at the time? Any idea? I'm not gonna hold you
yeah,
to
well,
it.
Murphy's, they sold it off, and it's strange how they did it. He didn't want to sell all the property at one time because of the tax. So they sold little pieces at a time, lot by lot by lot. So it kind of got extended on 21 years, I guess.
Okay.
To where we are now. But that piece below also was part of Murphy's, that little green place where it's got the 14 on it just north of there, which is all being developed right now.
All right. Thank you for your information, Howard.
Mr. Chair.
Yes.
I seem to remember something. I remember when we were doing the expansion of Murphy Ranch Estates that it was going to be single-family residences, and I don't know if staff can clue me in, but I thought that's what they were going to do. This is a change to that for them wanting to put in a fourplex now, because they originally came to us saying that they weren't going to do apartments because there was concern of apartments, there was concern of other stuff. I do vaguely remember them saying it was just going to be single-family.
I believe that this section was originally part of this plat, but when they started platting the lots and configuring the roads, this didn't, the way that they had to do it, and I can't speak to it exactly because the surveyor, the engineer would be the better person to speak to that. It was difficult to get lots in with the roads and the access because of this drainage ditch. So that's why they are proposing to plat off that 6.5 or so acre piece. This planning commission has also seen a couple of requests. They want to do 3 4-plexes right here. They're just waiting for the plat to get through the city. It was denied without prejudice for them to come back until the plat with the city was complete for them to do the 3 here. So
there's fourplexes proposed on that eastern
Right here.
side, and then one particular in this other piece that we're looking at right here. Yeah, I think I'm going to go back and watch some of that video, because I remember a lot of that testimony because there was a lot of contention about it.
there was a lot of testimony during the rezone hearing in October. It was October 5th of 2021.
And Brittany, correct me if I'm wrong, the other one that does show the other one that was denied without prejudice, that involved drainage, did it not?
Yes, and he did get the drainage improvements complete, and I believe he's working through the city to get those platted.
Yes, he has to go through that process too first, so we're somewhat down the road from them. Okay, thank you. Any other questions for Brittany? Would can I ask you one more question? would the representative, when you said perhaps the engineering firm or survey people could comment better on something, are they here?
They were.
I
I
thought they
saw
were.
Janelle was here, but
I
I
thought
don't believe
Janelle was
she's
here.
here anymore. And so was Kelsey from Pink Cabin LLC from
Okay.
Siteworks. But I believe they've left
All right,
since.
I was just hoping that it might clear up something that we don't know what's in our,
Right, and there was some infrastructure, and I did have some discussions, but exactly what those were, I don't want to speak to them. I don't believe I'm the, you know.
So no one's from P Cabin is here to respond to this?
They were here.
They
I
were.
did see them here earlier, but they are no longer in the audience.
Okay.
and we do have a number of speaker request forms on this. Go
Mr.
ahead,
Chair,
Travis.
that's absolutely fine. I'm leaning to continue it because I actually want to go back and watch that video and get those timestamps. Because I do believe, I think I was sitting on the commission whenever it came up through us. So I'd like to see what they were saying at that point in time, because that might give me, pause on how to move forward with it, just before we start this part of it.
Proposing a motion that I should ask for a
No,
second.
I want the public to comment on it, but I am leaning the mindset of continuing this regardless, so we
All
can
right.
see what is said.
Understood. All right, we do have a number of speaker request forms, and I'll go through these one at a time. Linda, you're here, so you're the next one up. Please. Please introduce yourself for the record and go on from there.
Hi, my name is Linda Carter, not Wonder Woman, but we live on Black Powder directly across from this drainage ditch. We moved here in fall of '21, and our realtor at that time, as well as the developer, Dan's Construction, had told us that they were going to be having single-family dwellings continuing to be built up between us and 44. And he was very clear that it was single-family dwellings. One of the reasons we chose this area was it is suburban. We did not want urban. And to me, I don't understand why they would put such a tiny little urban area in the middle of a suburban area. We paid a pretty penny. Really, realty prices are up, and since we've moved in, two other places new have sold, and both of those have gotten a higher value. I'm afraid that our property is going to go down should we start getting multifamily dwellings in there. We have traffic issues already. I understand that one of the conditions was to have some more ins and outs, but the amount of vehicles already in there is a lot. To have multifamily dwelling and potentially even more if they come back and want to rezone again for more, I don't see how our neighborhood is going to be able to handle that. I would ask that if you were in this position, having spent most of your life savings for a new home to retire in, and somebody would come in and want to change a small section urban, how would you feel about that? I understand that there's a housing issue, and I don't want to take away from that, but we also deliberately chose this because of what we were told. The zoning would be and the future structures. Our realtor had also told us that Murphy, and I'm going by his hearsay, I don't know, although it may be in some of the meetings, but Murphy had intended, he had donated a piece of land that was supposed to be for a small park. Since then, that has been changed into a home. It was kind of landlocked where people wouldn't be able to get into it, and they ended up building on there, but another piece of property was being set aside. I don't know if this is the area that was supposed to be set aside for it or not. You know, we're new to the area relatively, but we have kids, we have retired people, we have those who are going to be retiring soon, and I would just ask that you would please take this into consideration. So I thank you for your time. It's been very informative being here, listening to everything, and I appreciate the thoroughness that you give to listening to the voices of those concerned.
Questions for Linda? Thank you.
Thank you.
Annette? Matt? Thank you.
My name is Annette Matt, and I live on Colvin Street, just west of this proposed build, where they're gonna build. And I've gotta say that that has always been a watershed. We've always had water in that piece of property. We have the drainage ditch on the east side of the property. And last summer, they dug it deeper, they dug it wider, but we still had the water running on the field. Right now, it's a terrible muddy mess because they took all the grass off, and it's really bad. I just don't think it is a place to build. We don't have access to that land. You have to come in from the south. I live on the west side, and my property borders that. And if they put a single house in there, that would probably suffice, but I'm going to tell you, whoever builds in there is going to have a water problem. We have water problems because there's underground water springs all over that area. I've got a sump pump in my basement, and my basement's above ground. So you can just imagine what's going to happen if they put any housing in there. They're going to have constant water problems because we got underground water there. You dig down a foot and you're going to hit water. So I'm totally opposed to changing it. I understand suburban means it's supposed to be single-family dwelling, and this lady said it's going to be a duplex or a fourplex. To me, that's not right. To me, suburban means single family because it said you're going to have a little grass around your place and be able to plant a garden if you want. So they're changing the whole concept of what Steve Murphy and his mother originally wanted for the place when they sold it to the first contractor. So I'm just letting you know I'm opposed, and it's a water problem that has to be dealt with. And if this water problem clear down to Highway 44, and I think you really have to seriously look at that. Thank you.
Thank you. Questions for Annette? Thank you, Annette. Sydney Cox?
Good morning. My name's Sydney Cox. I live on Black Powder, which is the back road. I'm going to use your little mouse right here. Sorry. It's this piece of this road right here. So button up the property that is we're discussing today. I am opposed to changing it from suburban to urban for many different reasons. I know that we're saying right now it's going to be a duplex, but that means that there is an opportunity for them to come back and say, we would like to actually do apartments instead of duplexes. Either way, duplex or apartment, I have concerns. Same as hers, that is constantly flooded all the time. My backyard, when I stand on my porch and look over my fence, the ditch behind it is full of water all the time. Anytime it snows and it drains, or anytime it rains. The area where they're trying to build that duplex is going to have issues, like she said. It's constantly underwater. The new houses that they built on Derringer Road at the end, there's a cul-de-sac that leads right up to this area right here. These folks have water standing in the middle of that cul-de-sac all the time. It doesn't drain. It just comes right from where they're going to build this new stuff into that road. And I foresee that if we just put that as a concrete pad and build houses there, it's just going to cause more runoff and cause issues for the other homeowners that live in that area. My husband and I moved here last year. When we built our house, like the other speaker said, we did pay quite substantial amount for our house that I was not expecting moving to South Dakota. But this is where we choose to retire, where we choose to live. And I would just ask you to consider that, because I know based off my market research that this will depreciate the homes in the area about 6.5%. That's the average of when you convert things from suburban to urban. I've seen it happen before in other cities that I've had to live, and that just would make a huge impact on not only myself, but the other home builders on that street. They're paying almost $100,000 more what I paid just last year, which is kind of absurd. So just consider that piece. The only other big issue I have with that is there is no other exit for them to go straight out to Longview. I know the construction will have some exits going out to 44, but the main exit for them will be through Murphy's Ranch with our road district. We're already having issues with the roads that we have right now. We're putting aside $100,000 to try to fix some of those roads just from the use. So all that traffic coming through there will make a big impact on those of us that pay the taxes to fix those roads. So I have a major issue with that. Additionally, I know you guys have a lot to consider because there is a national housing crisis, and I know Rapid City is growing exponentially, so you have to consider those kinds of things, and we definitely need more housing. I would just consider that that piece of property is probably not appropriate for the urban, keep it more suburban. I know with the Apple Valley, that is already urban, so I think that's pretty appropriate. But I think that piece of property that we're talking about today is definitely inappropriate to be switching from suburban to urban based off the things I kind of already mentioned. And then our neighborhood right now is a pretty safe neighborhood. I have, like I said, lived multiple different places, and I've never seen children playing outside. In the last 15 years of my career, I don't ever see kids outside in this neighborhood. They're always riding their bikes. They're always outside laughing. And I feel if we convert that to urban with the potential of apartments, it's going to greatly increase traffic, and then it's going to put those kiddos in danger. And I like to watch them riding their bikes. It's literally like the joy of my life every day. So I would just consider those facts, those opinions. Those are just mine. I think that piece of property right there specifically in question is not appropriate to switch to urban just because of the major issues with flooding, traffic, and then just safety for those of us and our house value. So that's all I have to say. Thank you for your time.
Questions for Sydney? Thank you, Sydney. Brett Whitmore?
Hi, my name is Brett Whitmore, and my wife Cindy and I live on 3325 Remington Road, which was the original primary access here. We're on the corner of Remington and Derringer. We can see any development that happens right directly to the west of us because it's only about 150 yards from our back deck window. We moved out here first in 2005. We were one of the very first 12 homes out there, and we've lived there now 18 years. It's hard to follow some of these other folks because they have better facts on some of the specifics. But I remember walking out there one time. It was an open pasture land. In fact, we even had cows out there in 2018. But for a long period of time, it was undeveloped. The west side of that drainage ditch was a swampy area. When you walk through, you get mud up to your ankles. Even with the drainage ditch in existence there, you never walked out there after rain because torrents of water would come from the north part of Rapid Valley down through that drainage ditch and on down through past Murphy Ditch. We are opposed to rezoning. We are opposed to amendments to the plan. We don't want urban. I wasn't aware that it had been approved in that context. My original discussion that I had, we used to look out our back window and watch plastic trash bags sometimes when they blow from some other parts of the neighborhood, and we'd see them in the backyard. So my wife and I would go out there just because we liked the view and pick up the trash out of the field. We enjoyed that view. We moved out there originally because we wanted to live in the country. We had lived in an apartment in Rapid City. We're both veterans, and so we have lived all over the place in everything from single-family homes to apartments. And so we understand the reason for apartments or multi-family dwellings. But we chose to live where we do because it was a single-family area. I went out there one day. There were, this was several years ago, and I'm sorry for the detail, but there was one of many surveying crews out there marking off plots with stakes in the ground, and many of those got washed away. But I asked the fellows out there, I said, well, what are you doing? Who are you working for or whatever? It was Mr. Davis at the time. And the gentleman told me, we're marking out single-family home lots. And that's all we've ever been told. Never multifamily things, never fourplexes, never duplexes, never, 3-story apartment complexes or anything like that. And I realize it might be not quite as bad as our imagination is going, but one of the things that really characterized that whole area for us was it was country. It was farmland. Gave us a little feeling, and most of what we deal with as homeowners, I think all of us can admit this, our perception of where we live is why we live there. We perceive that it's safe. We perceive that it might have a view. We perceive that there's good places to grow squash or whatever here. It's our perception is the reason why we live in a certain place. Sometimes it's also related to the cost. We moved out there because we wanted to be in the country. We wanted to be in the place that Rapid Valley has a reputation of being a countryside location. It's called Green Valley. That was the whole idea way back in the day. So we moved out there in 2005 with that in mind. Every indication that's ever been given to us by anyone in any capacity whatsoever associated with the people who own that empty land has always been single-family homes. Or I had heard the discussion before about a playground area for kids. Nothing else about anything else has ever been mentioned to us. So there you have that edge of the story as well. And that's all I have. I don't want to belabor this at all.
Question is for Brett. Thank you, Brett. Appreciate it. Next request I have is Kay. Mickey? Is that?
Like Mickey Mouse, yes.
Okay, thank you, Kay. Please introduce yourself for the record and go on from there.
Yes, I'm Kay Mickey, and I live on Black Powder. Where my house is, I would be looking right out my back window at an apartment building. When I moved here in September 2021 from Southern California, I had lived urban my whole life. And I wanted to be out in the country, or at least country to me, not around apartments and the areas, I like where I live. I like where I live. I like my house. I really like my house. When we moved in, there was cows there. And then there was the talk of around 100 single-family homes. And because our house is built up and the ditch is down, I thought, well, I'll still be able to see farm from, my back windows. But not if I have a 2-floor apartment building behind me. They'll be able to see me. They'll be able to see in my windows. They'll be able to see, I didn't want that. I did not want that, but that's what I'm getting. I'm worried about the traffic because there are a lot of little kids that are riding their bikes in the street and whatever. I worry about that. I worry about what comes with apartments, unfortunately. I just worry about the safety of the neighborhood. We already have had break-ins, a little bit of break-ins. We've had some cars stolen or broken into in our area. And, I'm sorry, what comes with apartments is not always the, cream of the crop people. I just don't understand. I don't want to lose my privacy. I don't want the traffic. I don't want, and I don't see if that's a watershed area. If they try to build something there, how is that possible? Is it going to sink in the ground like other places I've seen where the apartment buildings sink eventually over time? I don't even know how that could be approved to put anything on if that's a watershed and the water table are so high. I don't know. And mostly of what other people have said. It's covered what my thoughts were. My thoughts were But I don't want apartments behind me. I do not want apartments behind me, and I don't want to be urban again. It's like, take a little bite here, we'll make that urban because I have money and I'm gonna do something, and then we'll take this little part over here. And then where's the park for the kids? Where's the park? Where's the stuff that was promised to us? I mean, we really have nothing where we are. We have Dollar General and we have nothing, around us. We are really country. And if there's going to be up the street of Longview, I guess 400 houses or whatever's planned for over there, let all that stuff go that way. I don't know. Just move it down the street or move it somewhere else, but no multi-dwelling houses. These people jump the gun at the end of the street where it says proposed fourplexes. I thought that was shot down last fall, and then they've already got like the pads in. I don't get it. They've already started working on it, and then of course they've stopped. But I think they jumped the gun on that, and I think we're jumping the gun on this. We need to stay where we are. We need to stay suburban. Thank you.
Questions for Kay? Thank you, Kay.
Thank you.
Mr. Chair,
Yes.
I have a question for Jason. Jason, can you walk us through how they can develop in that particular area, if it's got water or if it was a watershed, or is it recognized as a watershed from us? I mean, is it a drainage ditch? Just so that we get some clarification on that.
As far as I know, it is marked out as a drainage area.
You said it is?
It is, yeah. As far as what their engineers would do to make that a buildable space, I'm not really sure. They would have to control the drainage and stormwater off that property no matter what they do. But, yeah.
So there is a process where if somebody's going to build in there, they can. They just have to, engineering wise, they're going to have to figure out how they're going to deal with all that water.
Correct.
Okay.
Jason? We've got other speaker request forms we're going to go through first. Excuse me, Annette.
Yes.
We've got other speaker request forms before we're going to let you do a rerun, okay? Thank you. However, if there is engineering done, it has to be stamped and reviewed by your department. Is that not correct?
Yes.
And what do you do when you review that?
So I guess it depends on what the engineering is. If it's just dirt work, we just require a stormwater erosion sediment control plan. If it's more than 1 acre, we need it approved by the state. Now, as far as foundations and things like that go, we don't inspect to that level for building.
That's what I was getting to. You don't challenge the stamp. The stamp is who said designs the parameter for the building, and you review that they put it in correctly and that you have
Because
drawings.
we don't have engineers in planning and zoning.
That's all thank you. Does that further answer your question a little bit, Travis?
Nope, that was more for the public, so the public has at least an idea of what goes into it.
Okay, thank you.
And if I may, Chair, just one point of clarification. So in this area, this is in the 3-mile planning jurisdiction of Rapid City. So all of the road improvements, drainage, and all of that is based on their engineering criteria manual. So we don't have, we can make comments, but ultimately the approvals for all of that goes through the city of Rapid City.
And they still use UBC as their
As
guidelines?
far as the building permits are through us, but when you're speaking about drainage and drainage issues and roads and things like that, those are all engineered and done through the city of Rapid City through their plating process.
All right, thank you. All right, the next one I've got is Blaine Campbell.
I'm Blaine Campbell. I live in Colvin subdivision, which is west of the area in question. I've lived there since 1979. I appreciate the open discussion and the fact that a number of my questions have already been answered by previous speakers. The question that really is uppermost in my mind, if I understand correctly, this commission and the county commission have approval for the comprehensive plan. Is that correct? So my ultimate question, because the map tells us that the property in question, which is on the board, was part of the comprehensive plan and was approved. So if certain entities, and they're not individual, there are no individuals named as part of Pink Cabin and KTM Design, did they produce any evidence as to why they wanted to amend the comprehensive plan, which has been approved by the county commission? Are they required to submit any reasons why they're desirous of amending the comprehensive plan? That's a yes or no question. And Mr. Chair.
That's what we're doing right now, Blaine. That's the review that you're talking about.
Well, where are they? There are plenty of residents here. Where are those who are wanting to amend the comprehensive plan? I sat in on a number of those comprehensive plan meetings, and it sure seemed like a serious subject at the time. And yet, here we are with the opposition not present, and we're trying to state our case, which we're talking to ourselves, basically. So, the only other issue that is uppermost in my mind right now, and I agree with Commissioner Lassiter on extending this proposal. There seems to be a urban, suburban, urban problem in the paper. Number 24, the one we're on now, which is amending the comprehensive plan, says present zoning suburban. And I'm not sure I agree with that, having heard the historical data that it was changed to urban previously. Some historically in 2021 is what I heard. I have no evidence to prove or disprove that. And I hate to bring up number 25, which we're going to get to, but that one says it's presently urban, which if I understand the history, is true. But the proposed zoning change is back to suburban. So I just have a lot of questions, and I'll stick to number 24 since we're going to be called up again for number 25. Where are the people from Pink Cabin and KTM that are asking for the amendment to what I thought was a very important development plan for Rapid Valley? Well, all of Pennington County, basically, if I understand it correctly. That's all I have.
Blaine, just to respond to what you're saying, we have a standing rule when we have you folks sitting here waiting. we take the testimony so that you don't have to come back again. It's on the record. And that's one of the reasons that they may not be in attendance. However, as they indicated that KTM had been in attendance, that
Right.
we still get your testimony so we didn't spin your wheels. That's the Planning Commission's approach to this, and we've pretty much stuck by that.
Well, I appreciate that. And certainly the time limitation when every other commission wants to limit your time, I'm astounded.
Well,
Congratulations to you.
Our Board of Commissioner liaison member already indicated that there's certainly some reason to consider continuing this, but we do go ahead and take your testimony while you're here so that if you're not here again, that it could be referred to or brought up again.
Thank you.
Thank you, Blaine. Any questions for Blaine? Thank you again. I have one more form, Linda Hayward.
Hi, I'm Linda Hayward, and I'm from 7860 Longview Road, which is down the road a good mile and a half from this area. I was participated in with trying to stop the development with the Apple Valley area. I have several issues on this area here. And again, just not to repeat, but one is for the water. What I want to say is the area right on Longview Road, the water comes through there from the north. And the little bit of rain we had just in the last couple weeks, a couple inches in one day, created an entire waterfall of water coming down from the north through that area. That water not only comes from the local area, but you can go, I'm not sure that you're all familiar with the Copperfield area, which is way north of our area, but the water system commingles and comes down from clear up there and comes down and goes through our area. It eventually gets to our area in one way or another, and one way is that Murphy Ditch. Murphy Ditch is a live ditch. It runs year-round. They turn the gates open even more during the summertime, which causes more water to run that way too. So that ditch, the water's deep there. It's very live there. Yes, they did put a drainage ditch down through there. I've been watching them build it. I see what they have. And that is not going to stop what they call that 100-year flood that's going to come through there and totally wipe out a lot. Someday, when we get a really bad storm, we get a really heavy, big 6-7 inch hailstorm, there's going to be damage. It won't be just these apartments that they want to put in. It's going to take out houses. I've been out there since 1970, where I am at. And shortly after I bought my place, I was 16 years out of the city, 16 miles out of the city limits at the time, and now I'm in the 3-mile limit. But at that time, we had one of those 100-year storms. We had a lot of snow during the winter. We had a lot of rain in the spring, and we had that big storm and that come down through there till the water was even running over the top of Longview Road. That draining ditch on the east side of me is no different than the drainage ditch that is right here in this development. And this has a bottleneck. It comes from a huge, large area and bottlenecks right into one small spot. In fact, there's a house that was just sold out there. The house has been sitting with that Murphy Company area for a long time that they built. And finally, somebody was, I have to say, dumb enough to buy it. It is like this distance from the edge of that ditch. They definitely would be flooded. I personally don't see how they could sell a house in that close to that ditch, but it has happened. When we were in a meeting, it was concerning Apple Valley and Murphy Estates. Yes, the LLC of Pink, Andy was part of that. Andy was the speaker for them at the time. He did state that they would build houses and in harmony with the area. The houses that are in harmony with Murphy. The area where I'm at, there's less, everybody has an acre or more. But in this area down here, at this time, it's not an acre or more. But at the time, that area was actually a city called Murphy. And this is all built up since that one person started selling off that property. And these houses go from Longview Road down to Highway 44, and there's more and more and more of them going in. If you drive out 44, you can see some of their construction. You can see where they built that ditch to go down and through and comes out 44. There's going to be a big problem on 44 if we have that big storm. Because that water's going to come out right down there and shut the highway off. I don't know whether it goes under it or how it's going to go through there, but it's going to go through there. I'm also concerned with the access. They always say there has to be two access to get in and out of an area. Well, I don't see how they're going to do two accesses in that area for apartments on that side, on that west side of that property, for them people to get in and out. So I would personally like questions answered about the access alone. I only see one access going in and out of that. They can't access down the road from it because there's a fire station there, and then there's a private road, and then there's 4 or 5 houses in Murphy coming up there. So with that being said, are they going to go through there and out their private road? That situation is there's 5 houses there, and then there's a little road that crosses the Murphy ditch, and my son's house there, and another house is there. So if that being a private road, are they able to go in there and make that road or bring a road in from an alternate direction from down below? But something has to come in there because there's not 2 accesses that I see. So with Andy saying they were going to build houses of like harmony in that area, there's no apartments out there anywhere. Just across Longview Road, Kinney Quarter to Frog Pond, that property has been sitting there for many years. There's already apartments, the tall apartments, and some of the, I'm really not familiar with the names of all these kinds of apartments, but 4-plex, 2-plex, whatever. They're all over in that area. So if they own that property too, which I'm assuming they probably do by now, that's also going to go up in apartments. That's enough apartments in that area. We don't need any more apartments out there. We don't need to squeeze in little apartments there. I don't have proof of this statement, but I'm going to say it anyway. I was told that they told these people that live along that lane, maybe somebody could attend to that, I don't know, that they would leave 60 feet between the backs of their properties and anything that they built there. And from what I'm hearing, now they're down to 15 to 20 feet from the backs of those people's homes to put these 4-plexes in that area. So I totally do not think that's right. And for some of your information, all the land out there was agricultural. And then they had to get it rezoned to be able to come out there and build it all. And in our Apple Valley thing, which we're not talking about, they rezoned that recently against everyone's wishes, just like it is going on here today, and it went through anyway. And that was done illegally, actually. So what I'm suggesting is that you check out with the city planning, because there has to be some research done on this water part of it. The water thing is the main issue with this whole thing going in there. Because if they did not do the research with the wetlands to make sure that this is accessible to be built on, which I would like to see the paperwork if they've done it. Because that research was not done for the Apple Valley area, and it had to go back and be done. And I still have not ever seen any paperwork on that. So they need to get some real ducks in order before they would ever be allowed to be in this area. And I have to restate, that bottleneck is going to be something else. It's going to take out a lot. Any questions?
Questions for Linda? Thank you. I don't have any more speaker forms, but I do note that, just for the record, we have a letter from an Adrian Holt on this item, and Linda Noir, as well as the copy of Mr. Davis's letter from that involves Howard Rice's testimony, just for the record, so that those items are recorded. And I hope I did not. I didn't mean to upset you, Commissioner. I had let Brittany sit down. When you were concerned when I wasn't trying to question your understanding of the engineering, I just had to let Brittany sit down. I should have said that I was interested in knowing whether your question was completed and answered.
I was done.
I apologize.
Didn't notice it. Yeah.
Now, it seemed to me you had a motion.
Mr. Chair, I'd move to continue this item to the June 12th Planning and Zoning meeting.
Second.
Moved and seconded to continue this item, which I'm going to back up, is 23-05 to the June 12th Planning Commission meeting. Discussion from the audience. Yes, ma'am. Please introduce yourself again for the record.
Sydney Cox, just one thing to add, the notice that we all received as residents about this meeting said it was going to be today, and that the second one would be on June 6th at 10:30 a.m. So if we're doing June 12th, I would just,
The June 6th will no longer be a valid date because we're continuing it here, so that moves to June 12th, and then the follow-up meeting could potentially be what date? The 20th.
awesome. Are they required to send out a notice for the update? Because I know there's a lot of residents planning to come June 6th.
Not a new notice for the update. It will be publicly noticed from us, right?
On the site, yeah.
On our agendas?
There will be no notice going out to the 500 feet. It'll just be on our agendas.
Wonderful, thank you. I'll just let the road district know. Thank you.
Yes, ma'am. Linda? Please introduce yourself again for the record.
Linda Carter again. Speaking about the water issue, I know that we, being right across from the drainage ditch, in 18 months did not have our sump pump going at all. Last weekend, it went for 3 days off and on. Our basement is not below ground. Our neighbors next to us who are not able to be here today, they also have an above-ground basement, and their sump pump ran nonstop for the first time in 18 months last weekend for, I think, 3 or 4 days. So I don't know anything about engineering, but there is a big issue with water there. And I don't know how anybody could clear. I used to live in Florida, southern Florida, where they used to have to dig out just to get houses. I don't know how they would be able to do that there successfully. So,
Thank you.
thank you.
Discussion from the commission. Hearing none, all in favor of the motion signify by, yes, sir? I didn't see your hand when I asked before, I'm sorry.
Jim Hayward, Longview Road. Commissioner Lester, I can get you timestamps on that video that it was mentioned.
I would appreciate that.
I can
That
get
saves a
to
little bit
you.
of my time of research.
And when Apple Valley was going through this process, because we were involved with court over a year, the Planning Commission moved it forward without a recommendation at the time, and the county commissioner approved it. And when it went through court, the judge agreed that it was improperly done. But he talked with the commissioners again, and they would come up with the same result. So it got approved again in that way. That's all. Any questions for? Have anything? I can get that to you. I'll send an email to you for it.
Okay, appreciate
it.
Thank you. Yes, ma'am. Please introduce yourself for the record. I do that because there's actually people that just listen to this. And
Sure.
it's required that they have some idea who you are and speaking.
Sure.
Thank you.
I'm Cindy Whitmore. As Brett mentioned, we've been on Remington Road for about 18 years. I'd simply like to ask you guys to just reconsider the historical precedent that's been made a point of here today, that we've had close to 20 years of single-family homes. From the beginning to the current new residents, we've been told to expect only single-family homes, and that was the original intent of this development. And the proof is all the residents that are already out there. And this one little section, regardless of water issues, to suddenly have this little section be different than the rest of the neighborhood, including the pre-existing neighborhood at Colvin to our west, those are single-family homes. It seems kind of insulting to consider putting multifamily dwellings in the middle of what has been for close to 20 years a single-family residential area. That's all I have.
Thank you. Anyone else? Yes, sir. Please introduce yourself for the record.
My name is Matthew Fairbanks, and I'm actually the foolish one about the house closest to the drainage ditch there. It'd be lot 10 off of the end of Derringer. And, you know, I have kind of the same concerns as the rest of my neighbors do. With an addition to one would be that they are still selling, when they're discussing this property, when they're showing homes, they're still discussing it in the spirit of single-family homes. The way that they laid out the neighborhood suggests to me that that was always the intent. So I would ask the board to consider that in some of your decisions, to carry on the spirit of that design of that neighborhood, and, you know, protect the residents that have lived there for a long time. And they were sold a promise, and now it's kind of getting switched. So at the end of that day, I appreciate you guys considering my time and my thoughts on it. But
Thank you. And it's Matthew? Anyone else? Discussion on the motion. And the motion is to continue to the June 12th. Is that correct? Yep. And it was seconded as well. Any other discussion from the commission? Hearing none. All in favor of the motion signify by saying aye.
Aye.
Aye. Opposed? Motion carried. Item number 25.
Good afternoon, Commissioners. Brittany Molitor, Planning Director. Item number 25 is rezone RZ 23-08 to rezone .13 acres from urban residential district to suburban residential districts. And I would ask the Commission, because this is related to the previous request, that this is also continued, because I think that they need to go at the same time.
Mr. Chair, my motion would be to continue item 25 till the June 12th meeting. Item 25 is rezone of RZ 2308.
Second. Is there a second? Second. Moved and seconded to continue RZ 23-08 as a related item, and that was the recommendation of the department. Discussion. I do think for the people that have spent their time here and waited to testify that this is the appropriate way to do this as well. Put them together. Let's get the applicant here or their representatives and get involved with this even further. Any other discussion? Hearing none. Yes, sir. Please introduce yourself again for the record.
Blaine Campbell, resident of Colvin subdivision. Can someone explain to me the 0.13 acres?
She's coming up behind you here.
Oh, you're welcome. So when this was originally rezoned, they have to do it by a meets and bounds description, because this lot isn't actually created yet. When they did that, they included this very tiny portion in that meets and bounds description that was rezoned to urban residential. Now with the new plat, this portion of the lot of that meets and bounds description won't be urban residential. It won't be part of that new lot that they're proposing to request. It's like down along here. It's in this area right here. And that's going to be part of a different, some more platting of lots. So that's why. So then those lots don't have dual zoning on them.
So am I correct in saying it really doesn't apply to what we're talking about here, or?
I mean, it does and it doesn't. Yeah, but this was already zoned, urban residential. But,
Okay.
but for the future land use, the meets and bounds description is just for this current one, not the old one. So the rezone and the comprehensive plan have two different descriptions. I don't know if that makes sense.
Could I throw in one other thing?
Sure.
Most people don't understand, and we see it a lot. When you're talking meets and bounds, this is one part of it. There's another whole page of the description.
Right.
And it has to be accurate for the proper filing. And this needs to get cleaned up so that when this is filed, it does meet all the property parameters that are there for the lines.
Well, in the beginning, you mentioned that the two properties are different. Is
They're
that
stated differently out of the meets and bounds. In fact,
Yeah.
this one, its description is only maybe a third as long as the other ones. Yes.
Okay, that's helpful. Thank you.
Yeah, no, the one meets and bounds is for this whole parcel. The other one is for this one. That's why it's a different acreage.
Any other questions before we address the motion? Any discussion by the commission? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. On to item number 26.
I will read item number 26 into the record. It's ordinance amendment OA 23-01 to amend section 319 vacation home rental of the Pennington County zoning ordinance. And I did provide the updates of the motions the few motions that were made to date. And those are in the kind of grayish highlighted and then the items that were stricken. So.
Would the commission like to take a break before we, I see shaking heads. How about 10 minutes? We'll reconvene at a little after 35, 1:35. So the next item is item number 26, which is the ordinance amendment OA 23-01. And we've been discussing this item for a number of times, and it's been continuing. Just try to bring you a little up to speed. As I see it, there's only one item, and Brittany, correct me if I'm wrong, left on the table, and that's in regards to density. However, I see a problem bringing that off the table at this time. It is properly on the table, in the table position. However, if we discuss density at this time, I'm not sure we're going to be able to complete it at this meeting. We could open it up. However, then we can't address the ordinance itself, because then we bring up density later and we take it back off the table. There may be additional changes in regards to what we discussed regarding the entire ordinance. So I guess you folks have been sitting here and patiently toughed it out. I'd sure accept some direction. I'd like to pursue the density so that we can get this handled, or at least on the table, before we talk about the entire ordinance, and that's because there may have to be additional wording done to the ordinance in regards to density from what the commission talks about. I'm open for direction.
Mr. Chair, I'm just going to pass on Commissioner LaCroix's feedback to me because he was supposed to be here. I'm actually filling in for him because he's out of town. His main feedback was for the commission, for the planning commission on this particular item, was that from his perspective, he didn't have anything very directly about anything, except that anything that he would support or not support is going to be based on how it impacts health and safety. And that's basically his feedback. So that's how he's going to be looking at it. So if we're doing something that's not a health and safety issue, the question is, why are we putting it in there? If it is a health and safety issue, how is it impacting for us to look at it from the commission side of things?
I would assume density is at least a fringe item in health and safety.
Well, it's definitely been discussed in the past, and I think we've even discussed it with the 40-unit rule too. And so I think we're supposed to be having some more discussions on that for just regular housing and 40-unit rules. Sorry.
Mr. Chair, I think one reason we tabled density was because Kevin wanted to be here when we discussed it.
Yes.
And he's not here again. He had to leave to go to work, so. Do we go ahead without?
I guess my biggest problem is it is now 20 minutes to 2. I don't have any problem staying as long as it takes to get it. But that doesn't mean you're going to get necessarily the best thinking out of the commissioners, let alone the poor people that toughed it out. I'd sure take direction as to whether we ought to just continue the whole thing. And we really spun your wheels, which I do not appreciate. I don't think anyone foresaw some of the items and issues that came up on today's agenda. But give me some direction or guidance. I don't have the choice. I don't have the all authority to just wave a wand and say that's the way it's going to be. So you guys tell me what it is. You folks over there haven't weighed in at all. I sure expect some direction. Pat? Anything?
Is it me?
Sure.
Come on up.
But we have to have you up here. That's just the rules. There's actually people have no idea who you are or what you are. They just listen. So that's why you have to introduce yourself for the record and go from there.
My name's Patrick Ely. I'm the president of South Dakota Short-Term Rental Association. I'd have no problem continuing it. It has been many hours. I'm partially diabetic, so I'm getting a little case of the shakes. But if you'd like for us to talk about it, we can really talk about it. So.
Okay. Thank you, Pat.
Jessica Ginger, I think you should continue. It's been a long day.
Okay. Thank you.
Chair, the problem I have at this point is each meeting, we end up with the same thing. We put this at the tail end and we're out of time. Sometimes I almost think we'd be further ahead to hold another special meeting just for the purpose of this. But I don't know. We need the time someplace.
I'll weigh in on a thought on that. I believe, and I don't know how the board, three of the Board of Commissioners could not be here at the meeting at the same time because that would constitute a quorum. Is that not correct, Brittany? Under the state law, that would be illegal. But we do know that the Board of Commissioners, much in the order of what we did after the public testimony, have done some reviewing on this matter that keeps getting continued. And it would be nice to at least get some opinion can they write in and do that? So that if we move this up so that we could get some of their opinions and input in this? Or is that something that's not done? This is a highly unusual matter. Or can we move this earlier in the agenda where it's addressed in front of the other ones? Brittany, you can tell me.
Sure, I would recommend that you just move it to the beginning of the agenda then if you wanted to address it versus, because I think if you solicit out and, different things from the commission, they hear it at a different hearing time. So they will put their considerations
Sure, they've
in
got to
during their
review it. That's
hearings.
why we've got to watch making a quorum in there because that does hurt both avenues of approach to that ordinance.
So I would suggest either having a special meeting or putting it at the front of the agenda.
All right? I'm open to discussion on which way we go. I'd like to see it kept within the normal time, and I'd go for number one item if you want to know what I think, because I don't think the special meeting is totally the answer. It's just as tough to get folks here for special meetings as it is. There is no good time for everybody. They raise kids, they have jobs. But at least if we publish it, there can be a time to have the written comments, and we know it's on top of it, and we're probably going to make a recommendation when it's done, because we will have discussed density, and then we can move on to the ordinance. That's why I would rather see it the first item. Yes, Patrick? Please, you got to introduce yourself again.
Yep. Thanks, Charlie. Patrick Ely, once again. I would actually probably be better to have a special meeting. It was turned in last night. Lloyd will probably be forwarded, he's already had forwarded, I guess, to you guys for the next meeting. But our association has 211 members. We've been meeting extensively for the last several weeks. We've actually drafted our own counter ordinance that has come from industry partners, that's been reviewed by many lawyers, engineers, realtors. A lot more on the table than just density, and I think that's something that we would actually like to have a special time to present, to continue this discussion more productively.
Okay, Patrick, I got a question for you on that.
Yes.
Is it an entire different ordinance that would replace the ordinance that's in place, or is it revisions to what we've been looking at to review?
There's more than 400 revisions to the current ordinance. There was 37 issues that were identified as direct legal and property rights, and most other issues that were addressed. Again, we've had a round of these special meetings. I believe there was 3 of them. The forum discussion was very restricted. There were a lot of additional topics that were never brought up. We did address those in this document as well. And we wanted a chance to go through this maybe when we're more fresh to go through a proper conversation of what needs to actually be said here. So,
All right, and then my next question would be, when you turned it in, is it to the planning department or the board of commissioners? You tell me.
well,
I don't know. I don't know where you turned it in. So.
It was emailed last night at 12:30. Lloyd replied to me this morning and said he would forward it on to be in the packet for the next meeting. But again, just for the interest of those who maybe come for the CUPs, disputes, and everything else, maybe it should be something completely separate because it's such a unique and significantly large discussion item.
Okay. That throws in a new little wrinkle, but I'll throw that out. Any other questions for Patrick while he's up here?
Is it a copy that we can look at and see? Or?
Certainly, yeah.
Thank you.
While he's doing that, in order to move it along,
Thank you.
if it was turned in, as you say, to Lloyd, and I don't have any problem with that, I do believe it's probably appropriate that the Board of Commissioners then decide their direction on it to the planning department. If that's where it went, it didn't go to us. So we're not deciding the direction, correct?
Correct, but just so you pointed out, because Lloyd emailed me this morning once he received it I believe he sent it last night, is that, yeah. He obviously responded back to Patrick and saying that we would not be able to take that up in consideration today because of the late timing on it, and not having the opportunity to review it. So what you do with it at this point, if you decide that you're going to have a special meeting, then that's obviously a bit more information to consider for that special
I
meeting.
make one more comment. We work directly or indirectly as the Board of Commissioners' discretion within the laws that tell us what to do. Conditional use permits are different. It's all defined. I'm not sure whether it isn't appropriate that we wait to decide their direction or dispensation of it before we decide on a meeting or what we're doing. In other words, the continuance may not be for the next meeting. It may be for the meeting following that, just to get it to coincide with commissioners. I guess I'm more comfortable when the commissioners make a resolution that says, Charlie, we want you to consider this in such and such a direction. Is that correct, or am I wrong?
No, I just wanted to make a clarification, just when ordinances are presented in its entirety, there are certain ways to do that if they want to adopt it in its entirety. They want to use as talking points is one thing, but if they want to adopt it as is, propose an ordinance, there's very specific statutory requirements for that. So I just want to make this planning commission clear.
Are you telling us that they have to make some decision in regard to how they want to
Under
submit?
718A, it's basically like an initiated measure. They have to go through a certain process to submit it and have it adopted in its entirety versus using it as talking points.
And then Commissioner Lassiter, and this won't be on then the next agenda that you have, it will be on the agenda following based on what Commissioner LaCroy indicated?
I'm not telling you Commissioner LaCroy was going to put it on our agenda or not. I'm just saying, since it was submitted to him,
Okay.
he thought it was being submitted to him because he was supposed to be here, but I'm here in his
Oh, all
place.
right.
And that's what he was saying, is that it wouldn't be considered most likely today, since it came in at 12:30 last night, or this morning, whatever time it was. So that was
All right.
all he was putting out there, was that, thanks for sending it to us. If something else goes, if we continue, maybe it's something we can consider. But at that moment, I'm not going to guarantee you I can read through it, because the planning commission hasn't had time to read it.
All right.
But, Mr. Chair, if I can ask a question, and maybe this has been asked before, maybe I've just missed it when I read through the ordinances, and I don't have my ordinance binder with me just to look at it. Brittany, so Section A, purpose to establish regulations and standards. Is that what we normally say when we're dealing with an ordinance versus purpose is to establish ordinance for owners of vacation home rentals? Regulations and standards, I mean, that's back to my Air Force days. Is that the terminology we're using, or is it to establish an ordinance? I just want to make sure that we're using the right terminology.
It's to establish the standards and regulations for, because this is just a section of the ordinance, not the ordinance.
Okay, fair enough. Just making sure that.
Thank you. Could I ask Patrick to come up one more time? And this time you don't have to introduce yourself because I asked you.
Patrick Ely?
Do you understand that the dilemma I'm talking about here is the chair to get it so it goes the right direction? I'm not trying to take away time for you or give you more time or whatever. I want to make sure that it's handled correctly and goes through. There's been a lot of work done on our existing already. And we're certainly, I haven't even read this, you know, how substantial it is, but listening to your conversation, it's substantial. What do you think for continuance? Give me what your thoughts are on. Is this something that you're ready to present in 2 weeks? If we're given the direction by the Board of Commissioners, or is this something you want to continue for 30 days and then we address it?
2 weeks is good for me. I mean, we're well-researched. The references are not included on that, but there was more than 200 case law citations that was built from. It was covered in 33 different jurisdictions. If you choose to look at the entire citations and all that, it's available or can become available. But yeah, the current ordinance as it's been drafted lifts a lot of things to be undesired. As I said, there's a lot of things that were never even discussed inside the information sessions. And we're going to need, I mean, as I mentioned before, when I testified in those hearings, there's probably several hours of additional testimony that I myself could personally provide, but as well as the 211 members of our current organization.
Okay. Then my final thing would be, I haven't read this, but one of the things that I would think of right away is I'd want some confirmation you have 211 or 11 members.
It's on our Facebook page, sir.
So that's going to be one of my first questions when we address this. So I just wanted you to know I'm not trying to keep that away from you. That would concern me because there's a percentage there. We've had a lot of people indicate input into this. We had a number of people work very hard for a number of months on what we are looking at. And the idea that they've missed so many things, you know, I find that hard to believe, but.
Yeah, it's very unfortunate. What we have here is a very unique crowd. We have a public-private partnership of industry leaders that have come together, bankers, realtors, like I said, everybody's had a chance to look at this, people who are, you know, nearby living in adjacent to vacation rentals, or to be actually properly rephrased as short-term rentals. Okay. The whole conversation is much larger than what has occurred here publicly in the last few months.
Okay. I just wanted to clear that I probably would ask for some confirmation that you're speaking for those members. We see it in petitions. We see it in organizations that are registered. We ask for that. It's not, you can't just move forward unless you really do have those. And whatever ones you have, that's fine. But I'm questioning that we just automatically assume 211. So that would be one of my questions when we do pursue your follow-up here.
Are you asking for a member roster, signed petitions?
Some idea that you represent the people you say you're representing.
In what form would you like that, sir?
Excuse me?
In what form would you like that?
Mr. Chair,
Your choice,
if
I
you don't
guess.
mind.
Go ahead.
Usually there's a statement when other individuals bring something to us to say our community this is our view of said topic, and they write, we agree with this, and then whatever that is, and then they assign a document. That's what we typically see.
Are they like just one-page forms? Say people, so each individual signs those, or again, how would you like?
That's
that?
what we typically see from the Board of Commission. If there's a community that agrees fully with something or not with something, usually it's more that they don't agree with something going on. They write up a petition that says, we agree with this, or we don't agree with this, and then they all sign it, and they put their address or whatever to show that they're within the district or whatnot, whatever it happens to be. So something that you can have tangible evidence to show is probably a good way to go about it, not just Facebook.
Well, we're still a rapidly forming new organization. It's been, the bylaws just got approved last week, so it's just, this conversation affects so many people and expands so far that is actually has been the spark that's actually formed an entire community organization that our mission statement is that it becomes part of the regulatory environment, and that as a private organization, we actually strive that we have a seal of approval, that we ourselves approve of all the vacation rentals across the state of South Dakota as we grow, and that those that are in compliance with our policies, which supersede and also allow for more direction and discretion than any ordinances or laws would otherwise would allow for, so they'd have the South Dakota short-term rental seal of approval on those listings. That's what we're building towards, because we have, as a collection of business owners, we want to equalize the playing field, not just for our own benefit to protect our investments, but also for the protection of the tourist industry that ultimately we're serving, as well as the whole short-term rental community. It's more than just tourists, but that's what we're trying to shoot for.
Okay. Mr. Chair, might I point out, if we decide to continue this next one, and you want to put it at the beginning of the next one might be a little bit long as well. And I know some of those people were here for a long time, so maybe it could be considered for the following meeting, just if you're going to put it at the beginning. I don't know what the hot topic meeting points are or agenda items are going to be, but I just know some of those individuals were here. They're going to be coming back, I would expect.
All right. In fact, I understand what you're saying. And just two quick things. One, we do ask for this, like when there are road districts, water boards, that sort of thing. When somebody comes up and they say that they represent the water board and they're president of such and such, a lot of times they'll submit that 80% of their membership opposes something like this. And they do that. We do that, and that's common. As far as what you're saying, can we set it to a time so that we try not to spin these people's wheels? And, I know the Board of Commissioners use 10:30 as planning commission time. Is this something that would work?
I don't see
I
why
don't
we
know
couldn't,
how-
as long as it was very specific on the agenda that that's when it would be heard. Or a time
Not
that
before, yes.
it can't be before.
Set a time?
Can't be any worse than what we're into now. Maybe it'll work.
Okay. I'm sure. You have to abdicate to you because as the commissioner indicated, there's a couple items that are going to have a number of people coming. For the next one, I don't know how we can look at putting it together and picking up a time and letting the public know as well.
Yeah, there will be those two pink cabin, the rezone and the comprehensive plan, so not sure how long that one will take. Mr. Allards will be on there again. I'm trying to think if there's anything else.
I think we have a PUD that'll be on the 12th too. I can't remember.
I'm just trying to see if any of them were, that usually we don't know what to expect until after the 500 feet, the letters get noticed, and it's usually like within a couple days prior, so typically, that's when we start getting it in our letters of opposition, or within a couple days of the meeting date, so sometimes it's hard to know which items are going to be.
Maybe the June 26th meeting might be better.
Yeah, I'm beginning to feel that.
Or
Because
special
I'm not
meeting.
sure that we could just pick out 2 hours and say at 11 o'clock for the next meeting is going to work.
Yeah.
A
Yeah,
special
in the middle of
meeting.
an item.
Is that something we would take it 2 meetings, Patrick? Is that something that would,
Yeah, that's fine, yeah.
okay. What about you, Jess? Yes.
Don't plan around me.
Charlie, I, before we, I guess I'd like to know where we're going. Are we going to discuss the plan that they've put forward? Are we going to continue with the ordinance we have? I think we need some guidance from the Board of Commissioners and also from our state's attorney.
I would agree. Some guidance from Megan. She just
Then
couldn't
my
be here any
suggestion
longer.
would be to continue to the next meeting, and then that is addressed at the next meeting, based upon the reply we get from the Board of Commissioners. That would be my recommendation as chair. That may mean that people are going to show up and we're going to send them away for one more meeting, but it would be an appropriate way to have the information. We could read Patrick's information that he submitted, and we'd be more informed as well. Chair to address the motion. We've already gotten direction from Patrick, and yes, let me get a motion on the table and then we'll discuss it. Dessel, don't even move. Anybody care to make a motion to continue this and leave the item on the table as well, density, until next meeting, which is June 12th? Until further direction from the Board of Commissioners on this matter.
Yeah, that sounds good. I would move that.
All right, is there a second to that? All right, we're open for a discussion, and Dessel would like to be the first one to speak.
Members of the commission, Dessel Peterson, I was a member of the committee. I'm wondering if it would be helpful for you. I see what you're all kind of struggling with this brand new, and it looks like a fairly lengthy submission. And I'm wondering if it would be appropriate for you to send it back to the committee and have the committee review it and then have it come back to you, just as a way of trying to get your arms around
Continuity.
it, trying to get your arms around this, because all of a sudden you're being presented with something that's practically brand new and is in fact a rewrite of everything that's been provided to you.
It hasn't been vetted. It's a good idea, actually.
Dessel, and I've got to tell you, we need that. We can't decide that. It actually, your committee was established under the Board of Commissioners, so that would be really involved in the motion we just made. We're waiting for direction from the Board of Commissioners.
Actually, then couldn't we just move forward with a recommendation to the Board of Commission that the new ordinance and the existing draft ordinance, the new given ordinance and the draft ordinance be sent to the committee? Are we the only ones that can do that?
We've got to do that as a separate item.
Right, I get that. I'm just wondering, is the board the only ones that can send it to the committee, or can the planning send it to the committee for review?
They worked, the 7 members worked directly for you, not for the Planning Commission.
I would recommend that the Board of Commissioners make that motion based on the Planning Commission's recommendation.
So couldn't the motion be for planning and zoning recommends to the commission to have this sent to the committee
And reviewed for comments.
and review for comments?
I would agree as long as it was a separate motion.
I would make the substitute motion. I just want to make sure I'm getting the right terminology, so I don't put us in a bind either. So the substitute motion would be to get the planning commission is recommending that the new ordinance that was presented today by Patrick and the draft ordinance that has already been reviewed be sent to the committee to have them have conversation about it before presenting it back to the Planning and Zoning Commission.
I don't think that can be a substitute motion. We've either got to continue it or we got to address it today it was published. I do believe it could be a separate motion after we continue it, that we're sending a recommendation along with the continuance to the Board of Commissioners of exactly what you said. But I don't think you can tie them together or do one without the other. We've got to continue it if we're going to continue it, and it has to be continued to a specific date.
Yeah, I don't have any problem continuing it, but I think that we should, during that continuance period, not really make a decision right now that we're going to either accept this or accept that, that we take it back and we look through this and see what kind of similarities are to the existing ones, what might work, what might not work. You know, we've already got, again, well, we've got one that's just being presented, and then we've got one that's already in the books. And there may be some similarities, a lot of similarities, no similarities, I don't know, without seeing it yet. But at least then we would have a feel of, yeah, this has really got to go back to the committee, or we can fine tune some things here. It's my 2 cents on it.
Does everybody understand me why these are separate? We have to do something we publicized
Yeah.
for today. So there has to be a continuance to some specific date. But we can make any recommendation we want. And I like the commissioner's recommendation in regards to our recommendation to the Board of Commissioners when they look at this.
So then I would make a substitute motion to continue this to the June 26th meeting,
Okay.
right? Is it June 26th?
Well, June
No.
12th,
Nope, the following one. And there's a reason,
6th.
June 26th, and there's a reason why. But my motion would be to continue this to the June 26th meeting with a notice to the commissioners that we would like both of these items presented back to the committee for review and comments. That gives plenty of time for it to, I'm sorry, I should probably stop because that's not part of the motion.
How about if we just left it open still to the Board of Commissioners' direction to the Planning Commission on the handling? I just think if we keep it as separate motions, it's pretty clean. We can review it on the 12th again, and if it's not cleaned up by then from the direction from the Board of Commissioners, we continue it again. On the other hand, we need some avenue to make a recommendation to the Board of Commissioners, which I believe should be done by separate recommendation.
Do you think the board is going to get the committee together again between our meeting and your following meeting?
No.
That's the reason why I put it to the 26th.
No. I don't foresee that happening, but that's all right.
That's why I continued it to the 26th, just to make sure that even if the board takes it up and says we're going to send it to the committee, they have got time to do that. And then you're not having everybody come back on the 12th and tell them, oh, they're sending it to the committee, so no. I'm just trying to streamline that process.
We'd still have to publish if we reconvene some committee meetings, is that correct? And then the members, we need to contact them on what they would, what they want to follow. I just don't see tying that to the committee. I just see continuing it and a recommendation, and then after that, that may take 2 more meetings. I don't know how long it's going to take. I don't know what the hurry is. There isn't any hurry in my mind, as long as we do it correctly.
Oh, I understand. I was going to make the 2 motions, but I'm saying continuing it to the 26th gives
Sure.
plenty of time for the commission to evaluate it and determine whether they're going to send it to the committee and potentially the committee
Oh, I
having
thought
time.
you meant the committee to look at it by then. I misunderstood. I apologize. Then that's good. I think we got to do it because of publicizing.
So then my substitute motion would be to continue this item until the 26th of June.
Is there a second to that?
Second.
Moved and seconded to continue Ordinance Amendment 23-01 to the 26th of June Planning Commission meeting. Discussion from the audience, from the membership. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried.
Mr. Chair, the second motion is what you asked for, is that we send a recommendation to the Board of Commission to send both ordinances to the committee for review and comments.
Is there a second to that?
Second.
Moved and seconded to send a recommendation to the Board of Commissioners. I guess all we can say is they consider sending this, would that be appropriate?
Consider sending it to the,
Back to committee for review, both items.
correct.
Does that sound right, Brittany? Or something that we can publish and live with? Okay.
Mr. Chair?
Yes.
I'd like to make sure that the motion says that it's a draft, that we're that we're recommending sending the draft ordinance and the language provided by the South Dakota Short-Term Rental Association. Is that right?
That's fair.
To the committee. Don't call it two ordinances, I don't think, because it's not.
And we should put as revised, currently revised, because
As
we haven't
revised,
done
okay.
density yet. Okay. Everybody live with that?
And I'm okay with that.
Now, how,
You need a
how
second.
messed up have we got you, Jerry?
You need a second? Oh,
Yeah. Oh,
yeah, I
second.
guess you got to figure out where we got to clarify for Jerry.
Second to it, please.
Oh, it's Mike seconded it.
Oh, you did second?
Yeah,
Okay.
I thought. Okay, how messed up have we got you, Jerry? To-
She
We're comfortable?
followed right along what we
All
were
right,
doing.
very good. All right, discussion from the audience on that. Does everyone understand what we're going to do? I think you want to say something. Please introduce yourself for the record, Joyce.
Joyce Chagru. What I have to say doesn't speak directly to the motion. Maybe I should do it under public comment. Would that be better?
If it doesn't
'Cause it
speak
is-
to the motion on the floor,
Yeah,
I'd
it's not
appreciate it if you
strictly-
did.
Yeah, okay, I'll do it
Thank you,
under public
Joyce.
comment.
Mr.
Yes,
Chair.
Patrick. One more. again.
Yep, just to clarify, so this will not be heard again until the 26th, but the committee, the Vacation Rental Committee may take it up sooner?
It depends on what the Board of Commission decides.
Yeah.
I will be there
Okay.
and give them reasoning, and I would hope that they would say, let's send it there, but maybe they don't want to do that. I'm only one of five. I can
Okay.
only
Of
just
course.
give them the input and then go from there.
Okay. And for the record, when's that meeting, the next commission or committee?
Well, the next commission meeting is June 6th.
June 6th. Okay, thank you.
Thank you, Patrick.
And I won't
Any
be
other
there.
discussion
I have to get
from
the
the audience,
information out because I won't be there.
from the commission? And I'm comfortable with it too, so I'll just weigh in there and tell you that. All in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried.
Item 27, the County Board Report. The Board of Commissioners concurred with the Planning Commission's recommendations from the May 8th, 2023 Planning Commission meeting.
Okay, we got that one. Items from the public. Joyce, we know that you want to speak. Huh?
Joyce Chagru. Just some thoughts, and I've been trying to work through this in my mind over the last few weeks, and today it's been clarified for me. We're going through an evolution here, and that's always complicated. When we started the first ordinance, it was for vacation home rentals, and those, with a few exceptions, were family-owned homes for vacation, and they rented them out when they weren't there to cover their expenses. They were all exclusively at that point in District 1, out in the hills. They're the kind that you heard today, pretty much. We're now in a whole different world. We now have, and I've been doing some reading on this, across the entire country, short-term rentals. A lot of those are urban or suburban. And what made me step back and try and think through this was when I started hearing about them out in Rapid Valley. We didn't have any VHRs out in Rapid Valley when we started this. They're a whole different type of rental than we dealt with originally. I think they're used for other purposes. I now know that there are condos that are owned by businesses who have traveling personnel, and the traveling nurses, for example, or doctors move through them. I talked a little bit with Brittany after the last meeting, trying to sort this out because it's so confusing to me to try and write or work through an ordinance that originally started with family vacation homes, and now we're dealing with short-term rentals that have nothing to do with vacation. So it's a mix of things, and so it's complicated. And I think the idea of moving it back to the committee is a good one. This is a good timing for all of this because, like me, I'm still thinking VHRs out in the hills. That's not where the big influx is going to be. I think it's going to be in our Rapid Valley ones, multifamily, whatever. It's a whole different ballgame. And I'm sure the committee, I wasn't on it, of course, but they did discuss this. But there is a huge amount of information out there now on short-term rentals. And they're not talking vacation homes. They mix the two together, but they're quite different. So anyway, I think it's good to move it back to the committee. Because I think we've brought in the newer side of it and try and weave the two together, which the SBU and the CUP sort of do, but I'm not sure. I remember Kevin, well, I think it was Kevin last time, or that was concerned about having standards for the less than 1 acre. And so that's where it's going to be. It's going to be less than 1 acre. And so that's where the big influx is going to be, as I see it. So it's a whole different ballgame. And we're in transition and evolution, I think, here. And maybe that, my thought about that might help. This is just a process we have to work through because the whole environment is changing. Okay,
You, Joyce. I also have requests from.
questions? No. Okay.
Let me say something, Joyce.
Sure.
The thing that concerns me from a businessman's point of view is the amount of time we've taken already on this amendment. I mean, we've had special meetings and, tons of people have come in from all over the place. And all of a sudden now we're looking at it, well, now maybe we're just going to, I don't know. This is an interesting thing. It really changes the course of our thinking.
It's an interesting time when this happens. It always is. It's really complicated and difficult because some, like me, for example, I'm still thinking VHRs like in my community where I live. That's not what the big deal is out there now at all. And do we need the same standards or don't we? It's a good question.
Thank you, Joyce.
Thank you.
Dessel, I had a request under public for yourself. Please introduce yourself for the record.
I'm Dessel Peterson, 22598 Hazel Lane. I have a question about where the video is from the April 24th Planning Commission. It is not on the website, and it's noticeably absent. Every other meeting, there's a video, but the one from April 24th does not exist on the website. I did find it on YouTube right after the meeting, but it's no longer on YouTube either. So
We'll get it up on.
I'm wondering where it is and if we can have access to it.
It's probably just an oversight, and we'll get it up there on the video.
Okay, thank you.
Thanks, Dessel. I don't have any other speaker request forms for items from the public. Items from the membership. You beat up enough today? Huh? A few blows? All right. Well, I haven't got anything other than to compliment you. It's tough to sit through these things and again, you guys do a heck of a job. How about adjournment?
I move to adjourn.
Bet, second?
Moved and seconded to adjourn.
Aye.
Discussion, aye. Vote, all in favor of the motion?
Aye.
Aye. Opposed? Thank you.